Hello, everyone. I will start by saying good morning, good afternoon, and good evening, depending on the country you are watching this conference from. I'm glad to welcome more than 500 registered participants from 18 countries worldwide, IAPP members, ASCPD members, and members of this international community of privacy and data protection specialists. My name is Marius Dumitrescu. I'm the president of ASCPD, the Romanian Association of Privacy and Data Protection Specialists. And starting this year, I'm also IAPP KnowledgeNet Romania chapter co-chair. Today, I invite you to a trip around the world to find out the latest news on specific legislation in the field of data protection and privacy. And I think if Phineas Fogg needed 80 days to travel around the world, with the help with the new technology, today we will be able to visit 6 continents in just 4 hours. We have with us today 10 extraordinary speakers, and with their help, we will be able to understand the way in which the GDPR has influenced internationally all the specific national legislative systems, and we will talk about the challenges and the solutions identified to overcome them. I remind you, this is the second edition of this conference, Privacy Romania 2022, and that it is organized by ASCPD, which is a member of CDPO, the European Confederation of Data Protection Organizations, in partnership with the IAPP and the Romanian KnowledgeNet chapter. The access of the proceedings of this conference is free and does not require registration, but if the participants wish to obtain a certificate of participation, it is necessary to register either on the event website or through the portal dedicated to IAPP members. For start, I have the honor to introduce you a very good friend of mine, Mr. Sebastian Naste, digital economist analyst at Callen International, also IAPP Romanian KnowledgeNet chapter co-chair and a member of ASCPD Board of Advisors. He will moderate today's event and he will be our, let's say, guide on this journey. Hello, Sebastian. Hi.
Hello, Marius. Hello, everyone. Thank you very much for your kind invitation.
I just want to wish you a lot of success today, and I'm handing you the microphone for all the event.
Thank you very much. Hello, everyone. Welcome on board on this international trip. And as my colleague said, welcome to the second edition of the International Conference on Privacy and Data Protection, Privacy Romania 2022. As Marius said, in today's session, we are going to be discussing about the latest developments on privacy and data protection legislation across the world. In this panel, with my distinguished speakers, we are going to be discussing about different legislative systems, challenges encountered in implementing their national legislation, and solutions identified to overcome these challenges. We will also try to find out the degree of compliance by private and public actors in their countries, the powers of their national data protection authorities, concluding with some significant or not differences within their national legislation and the EU General Data Protection Regulation, or the GDPR. So, without further delay, let me introduce you to my fellow panelists. I'm really pleased because we have different countries around the globe represented in the panel, such as Australia, Japan, the US, Canada, Argentina, Belgium, Italy, Ghana, Russia, and Republic of Moldova. Again, just before I start, I would like to give you a very quick overview on the GDPR, which is seen as a global point of reference for other countries across the world. As we know, the European Union, with its GDPR, has played a pivotal role in influencing legislative work and privacy debates in other parts of the world. We know that the GDPR applies directly in all the 27 EU member states and in the member states within the European Economic Area since 25th of May 2018. In a recent research published by Callen International, we have seen various legislation in various parts of the globe, and we noted some interesting conclusions that I hope that will also be reached here within the panel, such as in some legislation there is a comprehensive data protection frameworks and the rules have extraterritorial applicability, such as the GDPR. Moreover, these countries have different lawful bases for processing personal data apart from the consent, which is only available in some legislation. However, we see that data protection framework and legislation is evolving from Chile to South Korea to Brazil to Kenya, Australia to Canada, from California to Indonesia. Many countries around the world are modernizing their privacy rules. Therefore, because the protection of individuals is increased, this facilitates a free data flow based on adequacy decision between the European Union and other parts of the world, such as the recent adopted adequacy decision between the Union and South Korea, or between the EU and Japan, or between the EU and the UK, because they are not part anymore of the Union as we know. Therefore, please let me introduce our first speaker, joining from Australia, Stephen Bollinger. Stephen is the country leader for IAPP Australia and the Chief Privacy and Data Ethics Officer in the National Australia Bank. Stephen has spent nearly 15 years in privacy and data protection on a global scale, working across 3 different continents. He held various key roles in large enterprises such as Microsoft. Stephen is going to tell us more about the privacy and data protection legislation in Australia. Good evening, Stephen, and thank you very much for accepting our kind invitation to participate so late in your time zone to our event. The floor is yours.
Thanks very much, Sebastian, and thank you to you and Marius for the gracious invitation. It's a pleasure to be here. I have to say it is midnight here in Melbourne, so if you see me nodding off, just shout and virtually nudge me, and make sure that I'm still with you. But I have to say it's always a pleasure to speak with my fellow privacy professionals around the world. So. Today, I'm happy to provide you with an overview of the Australian privacy landscape, as well as some insights into some of the changes on the horizon and how those reflect and interact or compare with the GDPR. So first, let me start by clarifying the scope of what I'll be speaking about, because Australia has a variety of privacy laws. Australia's Federal Privacy Act applies to Commonwealth government and private organizations. And most Australian states and territories have privacy or information acts which apply to state entities. Additionally, there are health information privacy acts, and I won't get into those. I will be focused exclusively on the Federal Privacy Act, which is the act most likely to apply to businesses operating in Australia. So the Privacy Act was established in 1988, and it's undergone significant revision since then. The most recent comprehensive updates were changes passed into law in 2012 and made effective in 2014. The current act is generally aligned with the OECD privacy framework, and 13 Australian privacy principles, or APPs as we call them, govern the standards, rights, and obligations around the collection, use, and disclosure of personal information, an organization or agency's governance and accountability, integrity and correction of personal information, and rights of individuals to access their personal information. I should call out that we use the term personal information here rather than personal data, and the term sensitive information rather than special categories of personal data. We also use the term privacy in the way that Europeans refer to data protection. Now, as you would expect, these APPs cover topics such as providing privacy notices to individuals, constraints related to the collection and use of personal information, the requirement to implement appropriate security measures, protections related to cross-border transfers, and complying with requests from individuals for access or correction of their personal information. The Act is enforced through the Office of the Australian Information Commissioner, or OAIC, and the current maximum penalty that can be pursued by the OAIC is 2.1 million Australian dollars, and that's just over 1.3 million euros. So much less than the maximum potential fines under the GDPR. Now, rather than taking you through each of the Australian privacy principles, I'd like to focus on some of the differences between the current Privacy Act and the GDPR regime that many of you are familiar with. As a foundational issue, Australia's Privacy Act is not supported by a broader human rights regime establishing privacy and data protection as a fundamental human right. So we have no legally enforceable equivalent to Articles 7 or 8 of the EU's Charter of Fundamental Rights. Now, to get into some of the substance of the Privacy Act, let's start with personal information, which is defined as information or an opinion about an identified individual or an individual who is reasonably identifiable, whether the information or opinion is true or not, and whether the information or opinion is recorded in a material form or not. Now, the key point of contention and distinction in this definition is that it is information about an identifiable individual rather than that which relates to an individual, as you'd see in the GDPR. Now, this, what seems like a small distinction in language, has caused some Australian organizations to have successfully used this language to defend their position that technical metadata, such as IP addresses and other network information, isn't actually about an individual, but is rather about network equipment, even if that information ultimately discloses an individual's whereabouts. Now, the OAIC doesn't agree with this interpretation, and this is one thing that we expect to be clarified in the forthcoming update to the Privacy Act, which I'll speak to shortly. Now, beyond this definitional issue, there is no discrete list of lawful bases for processing as you would find in Article 6 of the GDPR. Consent is one justification for collection of personal information, but there is also something similar to the GDPR's legitimate interest in that organizations can collect personal information without consent of the individual, where to do so is reasonably necessary for its business functions or activities. But note that there is no balancing test that you have to perform as you would with the legitimate interest test. Organizations can also use personal information that they've collected for secondary purposes, where individuals would reasonably expect that secondary use, or if they otherwise consent to that. Now, although there is guidance from the OAIC related to what constitutes valid consent, which is largely aligned with GDPR requirements, the Privacy Act provides for both express and implied consent, which we know would not suffice under a GDPR standard. Appointment of DPOs is not mandatory in Australia, and accountability measures are far less prescriptive than under the GDPR. In that context, data protection impact assessments or privacy impact assessments are not required, nor is the maintenance of a record of processing activities. Nonetheless, many organizations within Australia undertake these as a matter of best practice and to help them demonstrate compliance with the broader principles. Australia amended the Privacy Act to require mandatory breach notification from 2018 onwards, and the notification timelines are far more permissive than the GDPR, allowing organizations 30 days to conduct an assessment of a breach to determine if it requires notification, then notify as soon as practicable, having made such a determination. Australia's Privacy Act does not include the concept of controllers and processors, and cross-border transfers are generally permitted so long as the organization that's transferring personal information out of Australia has taken reasonable steps to ensure that the recipient will comply with the APPs, and the organization sending the information remains accountable for the acts of that foreign recipient, which is more similar to a Canadian model. There are no general data portability requirements within the Privacy Act, but Australia recently enacted the Consumer Data Right regime, which requires organizations to provide access to certain consumer data via standardized APIs on the basis of explicit customer consent. And that's being rolled out on a sector-by-sector basis, having launched for the banking industry in 2020, and it will next focus on the energy sector, and after that, telecommunications. Finally, striking a striking difference, I should say, between the GDPR and Australia's privacy regimes are the exemptions within the Privacy Act. And I'll speak to two of them specifically. The small business exemption excludes from the purview of the Privacy Act businesses whose revenue is less than 3 million Australian dollars per year. Now, there are exceptions to that for certain businesses such as health services, credit reporting bodies, and those whose business consists of trading in personal information, so data brokers. But the impact of this exemption is to exclude between 90 and 95% of all Australian businesses from any obligations under the Privacy Act, regardless of their collection and use of personal information. So just to repeat that, that's 90 to 95% of Australian businesses are not required to comply with Australia's privacy law. No privacy notices, no rights of access for individuals, no breach reporting. Now, the next exemption is the employee records exemption, which excludes from protection under the Privacy Act any employee records held by an employer. Now, this means that employees and former employees have limited means to make access, correction, or deletion requests. And further, employers have no transparency obligations when collecting personal information for employee records. They have no obligation to appropriately secure those records. And if an employer were to suffer a breach and disclose employee records, even some which may include sensitive information, neither the OAIC nor the affected employees are required to be notified. Now, my view is that these two exemptions are the greatest barrier to Australia receiving an adequacy finding from the EU. Now, I'll shift now briefly to talk about what's been the main privacy topic in Australia for 2021, and which I expect will continue to be the key focus for 2022, which is the proposed changes to Australia's Privacy Act. Now, as you've just heard, there are some areas where Australia's regime is lagging behind other parts of the world. The Australian Privacy Act review is being led by the Attorney General's Department, which commenced the review in late 2020 when it published an issues paper for comment. The paper called out key issues for consideration in the review, taking as input some of the recent regulatory inquiries that have been conducted, such as those looking at digital platforms and loyalty schemes and how they use personal information. Now, a broad set of stakeholders submitted comments in the response to the issues paper. There were over 100 responses. The Attorney General's Department reviewed these responses and published a discussion paper in late 2020, back in October, with more specific proposals for changes to the Act. Now, this discussion paper was open for comments until the 10th of January of this year, and we expect a formal exposure draft of legislation to be published later this year. Now, the scope of changes being contemplated for our privacy regime is significant. The discussion paper itself was over 200 pages. And so I won't take you through it exhaustively. I will just take you through some of the highlights and the things that I expect we'll see some changes in once we have that draft legislation. So first is the definition of personal information. As I discussed earlier, I expect the definition of personal information will be updated to align with international norms to include not just information which is about individuals, but which relates to them. Further, I expect technical metadata such as IP addresses, location data, GUIDs, as well as inferred data such as categorization of individuals into segments, to be brought explicitly within the scope of the Act as personal information. Next is consent. Consent is not currently a prerequisite for most collection and use of personal information, other than where it impacts sensitive information. Additionally, where it is required, the Act doesn't always specify that it needs to be explicit or opt-in, except in certain cases, again, with sensitive information, notwithstanding guidance from the OAIC on this point. Now, this has led businesses across Australia to take varying approaches to consent, from acceptance of general terms and conditions, to a link to a privacy statement, to a pre-checked box, to an unchecked box, and everything in between. I expect the requirements for consent to be tightened in the forthcoming Privacy Act to become much more aligned with the GDPR, and for inferred consent to be retired. We will likely see a new fairness and reasonableness test that applies in an overarching manner to all collection, use, and disclosures of personal information, similar to what you find in Article 5 of the GDPR, and I would say loosely aligned with the jurisprudence under the US FTC Act addressing privacy issues as unfair and deceptive practices. I believe some form of a right to erasure will be introduced, as well as accountability measures, which in practice will likely require privacy impact assessments for at least high-risk data processing activities. Cross-border transfer rules, I think, are likely to stay largely unchanged, perhaps with the introduction of Australia's own standard contractual clauses, but we'll see. Regulatory fines for non-compliance will almost certainly rise, the current proposed maximum being the greater of either 10 million Australian dollars, 3 times the value of the benefit gained by the organization from its non-compliance, or 10% of annual turnover in Australia. And finally, the small business exemption and the employee records exemption that I discussed previously are both targets for elimination. The small business community is understandably concerned about taking on further regulatory burdens. This, combined with the impact that COVID-19 has had on small businesses in Australia, may cause the government to leave the small business exemption in place in some form, perhaps lowering the revenue threshold to bring more organizations within the scope of the Act, whilst still excluding very small businesses. But if one or both of these exemptions are preserved, I think it will be highly unlikely for Australia to receive an adequacy finding from the EU on the basis of the updated legislation. So if that's the case, keep those standard contractual clauses handy. So I hope this has given you at least an overview of the Australian privacy regime, some of the key points of difference between it and the GDPR, and some of the changes coming soon. And I wish you all the best for the rest of Privacy Romania 2022, and thank you very much for the opportunity to join you today.
Thank you very much, Stephen. That's a great overview of the Australian legislation, and good luck for the future review. If you still have some time, 2 minutes, I would like to ask you 2-3 questions. We also have one interesting question from the audience. Sure. First of all, are there any notable fines which were imposed by the Australian DPA until this date? If you would like to share.
There haven't been significant fines from the OAIC. They have taken some more high-profile actions over the last year. So they had a determination against Uber for a breach that Uber had back in, I think, 2016 that related to ransomware. There were some interesting findings out of that the OAIC made with respect to extraterritoriality that international organizations might want to keep an eye on. They've also taken a couple of determinations against, well, with regard to facial recognition, one against the 7-Eleven convenience store chain and another against Clearview AI, which I suspect many know, has collected our pictures from everywhere it can across the internet to sell that on as part of its facial recognition database for law enforcement. So the OAIC partnered with the UK ICO's office for that. The OAIC did not impose or pursue a fine so far as I know, but the ICO, I believe, has announced an intention to fine, and I think the number for that is £12 million. But I could be off on that.
Okay, thank you very much. What about children's data? Are there any particular or specific provisions in any part of the Australian legislation? Because I know that at EU level, our European Data Protection Board is preparing a new set of guidelines when it comes to data controllers or processors to process children's data, because we have seen some cases where some companies didn't implement enough or specific technical and organizational measures to keep such data protected.
Yeah, unfortunately, no. There are not any specific provisions around the protection of children's data within the Federal Privacy Act. That is one of the considerations for the changes in the ongoing review. There are a variety of different options being considered. Some looking at specific age ranges, others wanting a more subjective approach to how you determine someone's capacity, which I think sounds great, but can also be quite problematic when you're an organization on one end of the computer trying to determine subjectively or individually for each individual their level of sophistication and knowledge becomes quite challenging. So, one of the other challenges with children's data is also the issue of parental consent that both Europe and the US have struggled with, in that it's very hard to get a verifiable parental consent that you can really count on. And so what you see is a lot of box ticking that looks like, where organizations are going through the motions to say they have parental consent, but in many of those cases, it's a matter of somebody else sending an email in saying, yeah, I'm the person's parent. And so it's one of those challenges. There are some changes that are proposed separate to, I guess, related to the Privacy Act that touch specifically on things like social networking and are proposing mandatory verification, age verification for all users of social networking, which I think raises a different risk in that we're going perhaps overbroad in the collection of personal information for all users of social networking, specifically so we can just identify those who are under a certain age threshold. So it's a difficult challenge.
Indeed. So then you think that the data age gate, or this so-called mechanism to verify the age, would be the success in getting children's data in a fair way, and would be the mechanism to verify that actually a parent gave his or her consent for that child to use a social network. And the key is not to gather more data to verify that the age of the users.
I think designating a specific age under which you require parental consent is the most logical way forward, rather than trying to figure out if the individual is savvy enough to understand what they're agreeing to. But how you actually get that and verify that parental consent, I think, is still a problem that we haven't solved.
Indeed. Thank you very much, Stephen. Thank you very much for your for being with us. We wish you a very great, pleasant night, and all the best there in Australia. And thank you very much for all the overview. We hope that one day the EU will start discussions or might have an adequacy decision with Australia to have a seamless flow of data between the Union and Australia. And until then, good luck with all the future changes that will be brought in Australia. We will keep an eye on them, and maybe at the next session next year we can discuss about all these new changes which would be adopted and implemented in Australia. Thank you very
That sounds
much.
great. Thanks very much for having me. Take care.
Thank you very much. And now I would like to introduce our next speaker, Takaya Terakawa. Please correct me if I didn't pronounce the name in a proper way. Takaya is a privacy consultant in Japan. Originally, he helped companies as a risk management expert, but GDPR led him into the world of data privacy and data protection. In addition to providing advisory services to major global companies in Japan and China, he serves on the IAPP's Asia Advisory Board and advises universities on privacy and security in their research. He will also publish a book on Chinese data-related laws in April 2022. I guess that many of us would like to read that book and the conclusions of the book. And Takaya, the floor is yours. Thank you very much for being with us today.
Hi, thank you for having me tonight, and I'm very glad to be here. So, yeah, today I would like to introduce some aspects of Japanese APPA, Act on Protection of Personal Information. I think the information of this law is not many in the market because usually Japanese PPC does not publish English version of information. So today I will briefly go through the history and the some feature of the APPA, but I don't think I have enough time to go through every detail. So just pick up some, interesting portion. But I hope this will, help you to understand some aspects of Japanese law. And maybe you are very interested in Japanese APPA because APPA got the first adequacy decision from EU. Okay, so anyway, let me start. First, so Japan's Act on Protection of Personal Information, we call it APPI, was enacted in April 2005. And since then, so we had several amendments. The first one was 2015, and the second one was 2020. So now every company is preparing for the applying the 2020 amendment, and the 2020 amendment will be effective from April 1st of 2022, which means this year April. So they are very busy, and so they are working very hard to adjusting their privacy policies or privacy management rules inside their companies these days. So which means I was very busy with that. So from the historical perspective, so Japanese APPI initially prepared based on the business requirements. So since Japan is doing a lot of trading as a country business, so it is essential to have a constant data flow with Europe, and seeing the European Data Protection Directive was enacted in 1995. Japanese government started, establishing Japanese Personal Information Protection Act. So naturally, the APPI copies the EU law a lot. So it has a very similar concept with EU privacy law. So which means it's easier for Japan to get adequacy decision because so we monitor the EU law very closely. So previously, before we have a a privacy law APPI, different sectors such as telecommunications or financial companies or financial sectors or health sectors or some other sectors provided separate personal information protection. And the APPI was created by integrating those laws into one consolidated law. So this causes, many non-expert a lot of confusion, and at the first glance, the APPI is a little difficult to understand. And in addition to that, since APPI is, applied only to the private sector until now, the government sector or public sector has a, different law for handling personal information. And it's been like that until quite recently, but due to the pandemic, so we noticed this is not a right way to handle personal information in Japan, and that causes us to create a omnibus law, coupling the private sector law and the government sector law into one law. And then, so from this April, APPI will cover both private and the government public sectors. So this is a very good movement. And as you know, Japanese APPI is known for receiving the first adequacy decision from the European Commission after the enforcement of GDPR, and based on the fact, some people in other countries may think that Japanese APPI is very, very strict. But in my feeling, I don't think so. So the APPI is rather a very business-friendly law, and you can be more relaxed about APPI. And as a matter of fact, so Japan is very aggressive in using data. So for example, recently, so we had a very interesting announcement, and the Japanese government said it will introduce a lifetime learning history tracking system. And using that tracking system, the government will give every citizen an ID, and using that ID, they will track the learning, history of each individual to, support them learning better. But this is kind of a lifetime tracking, and of course, the privacy professionals in Japan were very, very nervous about it. But yes, we will see what's going on. But we are very concerned about it. And the Japanese APPI is a business-friendly law, as I told you just now, and which basically allows businesses to use personal information as long as you put the purpose or you specify the purpose at the privacy notice. And you don't have to take consent for the purposes, and all you have to do is just show it. On the other side, the rights of individuals are restricted. For example, companies are allowed to impose fees when individuals try to exercise their right. So this is kind of similar to Australian law. So Japanese APPI does not based on the human rights protection, but rather protecting business safety. And another interesting point of APPI is outsourcing. So without APPI, outsourcing is not considered to be a disclosure of personal information. And until recently, and the obligation to protect personal information for outsourcing companies was very, very easy. So all they have to do is just place a clause in the contract and they request the outsourced company to have appropriate security measures in place. And the cookies and the IP addresses, they are not considered as personal information. And of course, you don't have to get consent for placing cookies. So like I said, so Japan is very business friendly, and so although we have a strict rule on the APPI, but in reality there are many ways to make the life easier for businesses. But the good point is, along with the, changes of the global trend, so there are some changes happening for Japanese privacy too, and they are good, in my opinion. So, for example, so people are trying to get a consent for placing cookies. And recently, people are trying to, be more careful about transferring personal information outside of Japan. And they came from, two incidents that happened in Japan. So let me introduce those two cases. So the first case, in the summer of 2019, one of Japanese large recruiting firms calculated student job offer decline rates based on the student's web browsing history, and they sold the information to client companies so that they can keep the students more successfully. So so this was done by analyzing and profiling individuals' behavior obtained from cookies, and this led a very, very, big dispute in Japan. So based on this, issue, the amendment of APPI, which took place in 2020, decided to regulate the cookie use, but they didn't regulate the companies who allowed to put cookies, but the APPI tried to regulate DMPs, data management platforms. And what APPI tries to do is request DMPs or other digital advertising companies to obtain cookies from individuals for collecting personal information using cookies. So this is a kind of an unrealistic approach, but by doing so, the PPC can protect businesses for placing cookies on their, the PPC can protect businesses by allowing companies to placing cookies, but the responsibility for protecting personal information is still maintained by requesting DMPs to getting consents. So this is the logic. And of course, as you may imagine, so DMPs will never get consent for the cookies, and as a result, so many Japanese companies are, you know, using the cookie banners to comply with the new requirements of APPI. So now more and more companies are using cookie banners. So this is one very interesting trend in Japan. And another interesting change in Japanese privacy is that the country has become extremely sensitive to cross-border transfer of personal information. So this came from another, incident we had in Japan in 2021. And with this issue, so one telecommunication company was accused for allowing Chinese company to access Japanese personal information, and the company had outsourced its development and monitoring work to a Chinese company, and by doing so, the company provided the access to those information to Chinese companies. And the Chinese companies access the personal information, and monitors the users, and improves the product. So this was not a illegal act, and it was rather normal practice for Japanese companies. But due to the recent political tensions, PPC tried to regulate this. So Chinese companies should not be allowed to access Japanese personal information, which this is what PPC concluded with this incident. So we are very surprised with this decision, but after all, this is a kind of a political decision, and we cannot do anything with it. But based on this decision, so now in Japan, so when you use a SaaS service or any other global services, you are asked very strictly where your data is stored or located, or what kind of access rights you provide to your third parties, or what kind of access you have to their data. So in some cases, one extreme company requires me that all personal information should be of Japanese people should be stored in Japan. So this is kind of ironic, for me to see this, because Japan is promoting free data flow of the world, and on the other hand, inside Japan, so there's a growing trend of data localization. I think this data localization trend is spreading all over the world, and I have a big concern about it. Maybe we need to build a better trust among countries, and we need to have a better rules among countries. So okay, so I have been talking around 20 minutes already, I think. So I will,
Thank you very much.
yeah, so let me compare some features of APPI. So difference between GDPR. So for the APPI, so we do not have a concept of a lawful basis, and the APPI does not provide the protection of children's rights, and the APPI does not have the right for deletion, erasure, or portability, and the APPI does not have a concept of controller or processor, but basically APPI structures very along with GDPR. And in general, Japanese people are very diligent, as you may know, and if rules are established, they will follow the rules. And as a result, personal information is handled with a relatively high level of care in Japan, I think. So I think, the protection level of Japan is rather high compared to other countries, in my impression. Okay, so that's it from my side. So thank you for the time, and thank you for listening to me.
Thank you very much, Takaya, for your very nice introduction over the Japan's APP. And congrats, because as we know that Japan was the first country that received the adequacy decision under the GDPR back in January 2019. And,
Yes.
and that's a great thing. And as we know, this legislative update, the legislative review of the adequacy decision is going on. But as I read the press statement of Didier Reinders, the EU Commissioner um, for digital matters, he was in a positive tone with a representative from Japan that
Yes.
this adequacy decision will continue to exist, and this legislative developments that you announced, I think that they are very well received by the European Union, because it's great that the public sector will be under the scope of the APPI
APPI,
and
yes.
APPI, and I was wondering if there are fines which would be applied for public sector institutions or entities who would not respect the APPI. This would be our curiosity, because under the GDPR, the Commission left to the member states to decide if within their national legislation they will apply fines against public sector entities. In some countries there are, in some countries there are not. So I'm curious which is the situation with Japan.
I'm sorry, I'm only a consultant to the private sector, so I didn't go through the public sector well. But after consolidating the public sector to the private sector rule, so there should be some kind of enforcement action from the PPC. I'm not sure if the fines will be applied. In my impression, the fines will not be applied to the public sector, but most likely.
We will see in April. We will see in April. Then we will see in April. And I was also curious about what happens with data from an EU citizen, right? So as we know, the data of an EU citizen can flow without restrictions to Japan without implementing any supplementary measures as the ones which were recommended by the European Data Protection Board last year, right? And we read the final, the public consultation guidelines from the EDPB, which were launched in December, that the transfer can only occur if there are two different entities, if it's not within the same company, and so on. And the entity that transfers the data should be under the scope of the GDPR. And my question is, if me, as an EU citizen, my data would be transferred by any given company to Japan, which are the mechanisms, which are the judicial and redress mechanisms which would be available for the EU citizens to contact maybe the Japan Data Protection Authority if my rights are not respected, or I could go directly to the company. Which are the means for the citizens to get this judicial redress for the EU citizens?
I think first path will be to the company itself, And then, so if the company doesn't comply with it, so you can place a complaint to the PPC, and the PPC will, regulate the company and the, let them follow the GDPR rule. Because as you mentioned, the supplementary rule will be applied to the EU citizen, and that means essentially the GDPR will be applied to EU citizens' personal data in Japan. So yeah, so you are safe in Japan. In other words.
Okay, that's great. Takaya, thank you very much for
Thank you
your
for having me.
introduction.
Yeah.
And we look forward maybe to organize another discussion after the new legislation in April will enter into force. Good luck
Yes.
until then, because we know that you have to prepare. It was the same storm here in Europe. Everyone started to prepare after 2016, after the GDPR have been published until 2018 that entered into force. We wish you all the best, and we stay in touch. Thank you very much for being with us.
Thank you very much, and thank you for having me. Bye-bye.
Thank you. Conscious about time, I would like to introduce our next speaker, Keir Lamont, or Layman. Keir, please correct me. Keir is a senior counsel with the Future of Privacy Forum in the team that deals with the US legislation. In his role, he supports policymaker education and independent analysis concerning federal, state, and local consumer privacy laws and regulations. Keir previously held positions at the Computer and Communications Industry Association and the Program on Data and Governance at the Ohio State University. Keir holds a degree from Georgetown University Law Center and a bachelor in political science and economics from University of Florida. Keir, the floor is yours, and thank you very much for being with us today.
Well, thank you to ASCPD and IAPP Romania KnowledgeNet for the invitation to speak. I've been invited to give a brief overview of the United States privacy landscape. I'll start with a short explanation of America's existing sectoral approach to consumer privacy. Second, I'll discuss some of the ongoing efforts to enact GDPR-style comprehensive privacy legislation in America. Third, I'll share recent engagement in the privacy space being undertaken by the executive branch under President Biden's administration. And finally, I'll provide some thoughts on the evolving privacy landscape across the 50 US states, where much of the action is happening today. So first, a high-level overview of US privacy law. The United States has historically followed what is called a sectoral approach to protecting privacy. Starting around the 1970s, the United States has enacted targeted legislation to address particular sensitive and risky categories or uses of data. As a result, the United States has a series of distinct privacy laws to govern specific concerns, such as children's online privacy, governed under COPPA, healthcare records under HIPAA, financial data under the GLBA, and even video rental records under the VPPA. Now, over time, an independent government enforcement agency called the Federal Trade Commission, or FTC, has also emerged as the top US authority to police against privacy harms. This has occurred for two reasons. First, the FTC has been specifically delegated the ability to enforce specific privacy laws, such as the GLBA, and COPPA. Second, in the absence of an overarching federal baseline privacy law in the United States, the FTC has also taken action to protect consumer privacy interests pursuant to its authority to police against unfair and deceptive commercial acts and practices. The Federal Trade Commission has made strong use of its existing authority. To date, the Commission has brought hundreds of privacy and data security cases that have reached settlements that have included fines and monetary restitution, disgorgement of illegally obtained data, and mandated both structural changes and oversight of companies' privacy programs. Perhaps most notably, the FTC entered into a $5 billion consent decree with Facebook in 2019 concerning allegations primarily arising from the Cambridge Analytica data scandal. which is, I believe, the largest ever fine for a privacy violation that has ever occurred anywhere in the globe. However, despite this history of enforcement success, the FTC currently lacks some of the authority that is enjoyed by comparable data protection agencies around the world. For example, in most cases, the FTC cannot issue a fine for a first offense of many privacy violations. The FTC also faces gaps in jurisdiction over nonprofit entities as well as common carriers. But in short, America has both long-standing legal protections and a culture of respect for individual privacy rights. American privacy professionals, such as myself, also like to note that the US was the birthplace of the globally recognized fair information practice principles. So America's historical approach to consumer privacy has had the benefit of targeting greater attention, greater resources, and greater protections to particularly high-risk data uses and data practices. However, in recent years, this model has come under increasing stress due to several factors. First, the scope of the collection and use of personal information has expanded dramatically in the big data era, which has had the effect of exacerbating gaps in legal coverage. For example, personal information protected at your doctor's office would be typically protected under HIPAA. However, that same information would not receive those privacy protections if it was collected by your fitness device. Second, the lack of a unified nationwide approach to privacy has prompted individual US states to step up and pass their own laws to fill in these gaps. For example, all 50 states have enacted their own distinct rules for when and how companies need to notify law enforcement or affected individuals in the event of a data breach. These are undeniably important rules. However, the lack of uniformity between the states raises compliance costs for businesses and lacks the benefit of establishing clear and consistent privacy protections for American consumers. Further complicating matters, to date, 3 states have enacted broad-based privacy laws, and there are increasing indications that many more may be on the way. I'll return to this later. And then finally, I would point to what some have called the Brussels effect. The implementation of the European General Data Protection Regulation has spurred the ongoing enactment and review of similar privacy laws in scores of countries. You'll see this dynamic play out at today's conference, where you have speakers from all over the globe who will be very much speaking in the same language of data protection, informed by the European Union. American political and industry leaders want a comprehensive US privacy law to have a seat at this table in order to continue to contribute to the development of these important privacy norms. American businesses also want to ensure the ability to be able to participate in global commerce by engaging in free flows of data with trust across national borders. So, due to these factors, around since 2018, we have seen a groundswell of support from both the American business and civil society communities calling for the enactment of broad-based privacy legislation. In response, lawmakers from both major American political parties, Republicans and Democrats, have introduced GDPR-informed proposals for privacy legislation that would establish baseline rights and protections for consumer information throughout the economy, while also placing obligations on businesses to process data in a fair and responsible manner. I will refer to such broad-based privacy proposals as comprehensive privacy legislation through this presentation. Now, I'll turn to a discussion of some of these recent legislative efforts to enact such a broad-based US privacy law. But first, it is important to know that the US legislative process tends to operate in a radically different manner than in the European Union. The United States Congress has 2 chambers, a 100-seat Senate and a 435-seat House of Representatives. President Joe Biden's political party, the Democratic Party, holds narrow majorities in both chambers, while the Republican Party holds the rest of the seats. However, due to a mechanism that is known as the filibuster, most major pieces of legislation, such as comprehensive privacy bills, will require the support of at least 60 of the 100 members of the Senate in order to be enacted. The practical impact of this means that bipartisan support from both of the major parties will be essential in order for the US to ultimately enact a comprehensive privacy law. Another important feature of the US Congress that often surprises many Europeans is that any of the 500 plus members of our bicameral legislative body can introduce a bill on any issue, and they frequently do. Since 2019, I have counted 16 distinct comprehensive federal privacy bills introduced or informally circulated. However, American political structures and dynamics essentially guarantee that a successful privacy law will have to come from bipartisan political party leadership on the House and Senate Commerce Committees. So, while many of these privacy bills may contain important ideas that will better inform the public debate over privacy, they will likely not be the legislative vehicle for the successful enactment of privacy legislation. Over the past several years, Republican and Democratic leadership on these important committees have been engaged in discussions on privacy legislation. While leadership on these committees have introduced legislation, though, there has yet to be a bill that has been introduced with the support of both major parties. Nevertheless, these bills from both Republican and Democratic lawmakers have included similar privacy rights and obligations that people who are familiar with the GDPR will recognize. For example, leading US privacy bills have included the following elements. 1. Broad definitions of covered data, including information that is linked or reasonably linkable to an individual. 2. Consumer rights to access, correct, delete, and in certain circumstances port their personal information. 3. Obligations that businesses adhere to transparency requirements to disclose information about the scope of their data collection, processing, and sharing practices. 4. The ability for consumers to opt out of certain uses and transfers of non-sensitive data and to provide affirmative consent for the collection and use of sensitive data. 5. Requirements that businesses conduct risk assessments of the processing of certain risky categories of data or risky uses of data. And then 6, beefing up the resources and enforcement authority of the Federal Trade Commission to look more akin to European DPAs, though the FTC would still enforce and regulate in other areas of the law as well, such as antitrust. So again, these are rights and obligations that have been included in the major American proposals for comprehensive privacy legislation. They do not currently exist in the US on a broad basis. So, with all this political agreement and areas of alignment between the major bills, where have lawmakers been getting tripped up? I identify 3 key areas where policymakers and stakeholders have tended to disagree. 1. Disagreement over enforcement. There was debate over whether the enforcement authority for a privacy law should be allocated exclusively to government regulators, such as the Federal Trade Commission and state attorneys general, or whether private individuals should be able to take legal action to enforce their own rights without waiting on the government to take action. On the side that advocates for including private enforcement from individuals, many worry that enacting a privacy law without giving consumers a mechanism to take self-help would essentially be a paper tiger, because government enforcers may be underfunded or may be unwilling to take action against certain privacy violations. On the government-only enforcement side, many worry that creating a private right of action will lead to a deluge of litigation seeking statutory damages for bare procedural violations of a law that would benefit plaintiffs' attorneys with costly settlements that would carry little connection to remedying actual consumer privacy harms. A second area of disagreement in the US privacy debate is over a federalism issue known as preemption, which is the extent to which a comprehensive federal privacy law should override similar privacy laws established at the state level. Opponents of broad preemption tend to worry that a weak federal privacy bill could override stronger protections for consumers established at the state level. They also argue that preemption could essentially freeze the American privacy landscape in place by preventing individual states from more nimbly reacting to protect against emerging privacy harms as technology and business practices continue to evolve. However, proponents of broad preemption tend to argue that a so-called patchwork of conflicting and divergent state privacy laws is emerging, which is needlessly raising the compliance costs for American businesses, particularly small and medium-sized entities. As the internet does not stop at state borders, they argue that individuals and businesses alike will benefit from the establishment of clear and consistent privacy protections throughout the land. A final area of significant debate in the American privacy conversation is how to regulate against discriminatory uses of data, such as the application of automated processes that have the effect of denying rights and opportunities to individuals based on their immutable characteristics. There are increasing concerns that in the world of big data, algorithmic inferences, and artificial intelligence, existing civil rights protections will become less effective in the digital space. Stakeholders are increasingly debating whether comprehensive privacy legislation can ensure that existing protections are fit for purpose in the data-enabled economy, or whether it is time to start drafting new anti-discrimination protections wholesale. Now, to date, disagreement over how to resolve these issues has repeatedly stalled out negotiations in the US between lawmakers from both major parties in Congress. However, recent scholarship and debate in congressional hearings have shown that these do not have to be all or nothing issues, further suggesting paths forward towards potential compromise on these key sticking points. Unfortunately, we have, as of yet, had no major breakthroughs on these issues in the federal privacy debate. Furthermore, given that the United States is in an election year for Congress, many observers suggest that there will only be a very narrow window to pass something as significant as comprehensive privacy legislation in the year 2022. So, in the absence of comprehensive privacy legislation, how else can the US government advance privacy rights and protections? I'll turn now to the first year of President Biden's administration and action that has taken place within the executive branch. President Biden took office exactly 1 year ago today, and so far his administration has been fairly active in the realm of data protection. Notably, President Biden has issued several executive orders pertaining to cybersecurity standards and best practices. The administration has also placed a high priority on negotiating a successor to the EU-US Privacy Shield Agreement to facilitate data transfers across the Atlantic. However, these talks have largely involved issues of data protection, data security, and government access to data, rather than businesses' use and protections of data, which has been the subject of my discussion. So, I'd like to highlight two areas where the US executive branch is gearing up to engage on consumer privacy in a meaningful way. First, at the National Telecommunications and Information Administration, or NTIA, which is an executive branch agency that is principally responsible for advising the president on telecom and information policy issues. In December, NTIA held a 3-day listening session on the subject of personal data, privacy, equity, and civil rights. NTIA is also expected to issue a public request for comments on this topic and to publish a report. These actions suggest that concern over algorithmic discrimination and biased uses of data will be a point of emphasis in this administration's ongoing engagement on consumer privacy. Second, also in December, the Federal Trade Commission announced that it is considering beginning a rulemaking process on so-called commercial surveillance that would involve the following topics. 1, curbing lax security practices. 2, limiting privacy abuses. And 3, ensuring that algorithmic decision-making does not result in unlawful discrimination. However, FTC engagement in such an undertaking without an explicit statutory grant from Congress would be a very procedurally burdensome process. So, while the end result could establish new binding regulations against particular harmful uses of information, it is likely it would not be able to secure the types of baseline consumer rights that Europeans enjoy under the GDPR. However, we are at the very outset of this process, and observers are eager to hear additional updates from the Commission. So finally, I would like to close out by discussing action taken on privacy legislation across the 50 US states, which has taken on an increasingly prominent role in the US data protection landscape in recent years. So as I have mentioned, 3 states have currently enacted broad-based consumer privacy laws. However, none of these laws will fully take effect until 2023. A brief overview of these laws. California was the first state to move on privacy legislation, which is significant because it has a massive economy and population, and is also home to much of the US tech sector. The California Consumer Privacy Act was enacted in 2018. However, in 2020, California state voters adopted a ballot initiative to substantially rewrite major portions of this law, creating the California Consumer Privacy Rights Act, or CPRA. I'd like to lay out some major elements of the CPRA, some but not all of which are carrying over from its CCPA predecessor. 1, the consumer rights to access, correct, and delete information. 2, transparency requirements. 3, the creation of a new category of sensitive personal information, which is closely aligned with the GDPR, and a new right for consumers to restrict processing of their sensitive data. 4, a right to opt out of sales and sharing of personal information, including for targeted advertising. And 5, a private right of action, the ability to sue as an individual, however, only for cases of data breaches. The CPRA also creates a new privacy-specific rulemaking and enforcement authority called the California Privacy Protection Agency, which is currently beginning a rulemaking process that will hopefully answer many key questions about the scope and application of the CPRA that are left open under the text of the law. This is an ongoing process that will be very important for determining the actual operation of consumers' privacy rights and protections when the CPRA goes into effect. Next, the 2 additional states that enacted privacy legislation occurred in 2021, and those are the states of Virginia and Colorado. While these 2 state laws do have some important differences with each other, for the most part, they follow the same legislative framework for protecting individual privacy, and many people kind of speak about them in the same breath. So, most observers agree that these 2 state laws, Virginia and Colorado, are somewhat more aligned with the General Data Protection Regulation than California's law is. Virginia's law is even called a data protection statute, not a privacy law, which is a big deal in America. So, areas of alignment between Virginia and Colorado and the GDPR. 1, Virginia and Colorado both follow a GDPR-style approach to defining and distinguishing between the obligations of data controllers and data processors. 2, both states define sensitive data that, while lacking certain GDPR-style categories such as trade union membership or philosophical beliefs, nevertheless require affirmative opt-in consent for processing of their categories of sensitive data. 3, the laws create opt-out rights for targeted advertising, sales of data, and profiling in furtherance of decisions that produce legal or similarly significant effects, which is a very GDPR-like standard. 4, both states contain risk assessment requirements in a manner that is very closely aligned with the GDPR. California may end up with similar requirements for risk assessments, but we won't know until the end of its rulemaking process. And then finally, 5, both Virginia and Colorado require businesses to establish processes to consider the appeal of rejected requests from consumers. I would like to note a couple of points of differentiation between all 3 US state laws and the GDPR. First, you'll have noticed that these laws tend to focus very heavily on opt-in versus opt-out mechanisms of consent. They also specifically delineate permissible bases for processing data, such as pursuant to a contract, consistent with consumer expectations, or for data security purposes. However, apart from one bill, which is legislation currently pending in the US state of New Jersey, American approaches to protecting privacy have typically lacked the legitimate interest basis for processing that is included in the GDPR. Second, while these enacted state laws do all include a consumer right to deletion, they tend to lack a European-style right to be forgotten, largely due to a different balancing of free speech interests under American jurisprudence. So, what comes next? While only 3 US states have enacted comprehensive privacy legislation as of today, we have tracked around 60 different comprehensive privacy bills introduced in 25 different states in 2021. I expect to see similar levels of activity across US state capitals in the upcoming year. some big questions about what will happen at the state level in 2022 include: 1, how many additional states will enact new comprehensive privacy legislation? As more and more states enact laws, it may grow easier and easier for other states to follow in their footsteps, so we may see an accelerating trend. 2, will these laws will any new laws enacted closely follow the California model, the Virginia and Colorado model, or take a mix of different approaches? If so, we can expect that greater divergences between state frameworks will further raise industry concerns about compliance costs. And then finally, how will state activity inform the federal debate? It is possible that movement on privacy at the state level will breathe new life into the dormant federal debate, both by motivating lawmakers to take action to head off a type of 50-state patchwork of state laws, and also by potentially informing the substance that animates new federal legislative proposals. So, while the enactment of comprehensive federal privacy legislation remains unlikely for 2022, your American speaker come Vacy Romania 2025 may be presenting on an entirely new US law. So, I'll wrap it up there. Thank you for everyone for tuning in. I'm happy to answer any questions that you may have if there's time remaining, or please feel free to track me down online with any inquiries. I am not hard to find.
Thank you very much, Kir, for your very kind introduction and your hard work, not only presenting the US legislation. We know that there is not a federal US legislation on privacy, but we know that there are so many sectorial legislation, as you said, the consumer protection, financial sector, even cybersecurity, some legislation which is related to privacy and data protection. And it's great to hear that many other federal states in the US are climbing on this privacy ladder. Let's put it like that, and they are trying to create a new legislation for the individuals, for their privacy and data protection to be better protected. I would like to talk a little bit about the elephant in the room, with your permission, about the EU-US Privacy Shield successor. We know that there are some discussions. There are very, how to say, technical. I think that we are already in the phase of the technical discussions for this Privacy Shield, which are great news. So that means that Biden administration and all his team met with Vera Jourova and with with Didier Reinders as well, and with the whole team in the Union, and they are in the middle of the technicalities of this successor of the Privacy Shield. And I would like to quote one European Commission representative: "We have made a lot of progress, but we are not yet there." And the quote here. I have one curiosity. Do you think that the Union should start by having an adequacy decision with one of these, let's say, 3 federal states, starting with California? Do you think that that would be a solution if we will be stuck in these technical negotiations? Or, in your opinion, what do you think that would be, let's say, top 3 necessary changes for the US legislation to have a new Privacy Shield successor? Thank you very much.
Sure. So that's a really great question. Obviously, those negotiations are ongoing. We are hopeful that those are successful negotiations. And I think the fact that we're not actually hearing a lot of things leak out about those negotiations suggests that they're kind of at the table, they're keeping it close-knit, and they're hopefully making progress towards a successor agreement. So the idea you raised that I've heard batted around before is whether or not there could be an adequacy determination applied to one of these individual states that have enacted privacy legislation. I'm quite doubtful whether or not that would be successful or that could work. For one, these are very much kind of consumer privacy bills being enacted at the state level that regulate how businesses use consumer data, how they provide consumer rights to data, and how they provide kind of transparency about their business practices. Now, and under the Privacy Shield, and if you read the court's complaint, the kind of issues were not really with the business's use of data. The issues emerged from concerns about the government's ability to kind of access the data, even if the businesses didn't want to share it, even if the businesses were doing everything they could and to protect that. So there's not really a mechanism in the United States where one of these states could try to carve itself out from the federal government's law enforcement agencies' ability to request data that were the points that were that there were concerns about, which led to the Schrems II decision. So kind of at this point, it's very much less so on the kind of commercial privacy side and more about the national security surveillance side of issues, and kind of figuring out how, either by executive order or by federal legislation, we can ensure that the necessity and proportionality standards for European citizens are met in free flows of data to the United States.
Roger that. And as we can see from a recent decision from the Austrian Data Protection Authority, the lack of a mechanism, transfer mechanism between the EU and US is currently affecting some businesses on both sides of the ocean. I have one question from the audience, but I'm also time aware. If you could give a very brief answer to this question. Given the proposed Ending Platform Monopolies Act that covers, among others, conflict of interest, including combining of data between platforms, is there a possibility to see the FTC tackling GDPR issues from an antitrust perspective?
I think that's a really great question. The new Federal Trade the chair of the Federal Trade Commission, Lena Khan, has a background in antitrust law. She is an antitrust scholar, and we've increasingly heard concerns raised from the Commission about issues at the intersection of privacy, such as the collection of large amounts of data, and how that impacts competition and antitrust issues. So that is definitely an area to watch going forward.
Okay, Kier, thank you very much. Thank you very much for accepting our kind invitation to participate to this international trip. And yeah, we will keep an eye on the discussions between the EU and the US, and we'll hope for a new Privacy Shield successor to be very soon in place. And we will keep in touch. Thank you very much, Kier.
Us as well. Thank you.
And without any further delay, I would like to introduce our next speaker, Amalia Bartel. Amalia is an independent privacy consultant and advisor, as well as a lecturer and academic programs advisor at the University of Toronto. Amalia is an IT insider and a specialist, and has been in the privacy compliance and privacy engineering space for the last 16 plus years. And she is a very passionate advocate for protecting personal data of individuals. I would also like to mention that Amalia is on the board of the Knowledge Flow and Cyber Safety Foundation, which is an education foundation for children, youth, and elderly, and recognized as a Privacy by Design ambassador. And Amalia led the creation of the Privacy Management Certificate program with the School of Continuing Studies based on COVID-5 standards and COVID 2019, as well as on ISACA privacy principles, as well as the IAPP curriculum. And she is the co-founder of Manage Privacy Canada, a premier boutique privacy management firm in Toronto, Canada. Amalia, the floor is yours, and thank you very much for accepting our kind invitation to speak and to take part of our international trip around the world. The floor is yours. Thank you.
Bună ziua! Mulțumesc foarte mult! Sper că mă auzi bine. La mulți ani tuturor celor din spatele camerei, celor care participați, dacă sunteți români, peste tot, la mulți ani. I know I'm supposed to present in English, so I will, but I couldn't help myself. I don't often have opportunities to speak in Romanian, and I'm very pleased. So thank you for the invitation. Unlike my colleagues, I decided to come up with some slides because just like, well, I'm not going to compare Canada to the US, but I think a visual is maybe going to give you a bit more of an understanding of the Canadian landscape. So just wanted to say that I think privacy can be beautiful, and I'm going to leave that with you, but it is just a kind introduction to what you're going to see next, because next we're going to have a quiz to see if you understand the geography of Canada. Canada is made of provinces and territories, much like the United States is made of states. But in Canada, as well as comparatively similar to the United States, we have different statutes and different laws in each province and territory, and they range from public sector to private sector. So what you see here is, somebody called it a great law scholar. By the way, I'm not a lawyer, so I'm telling you all of this from the point of view of compliance professional who understands privacy. So there are laws for the public sector, for the private sector, but there's some sectoral, mainly in the health space. We don't really have privacy laws for financial space or other industries, whereas the US does. So just to put it into perspective for you. In order to understand what's happening in Canada from a legislative landscape, you need to understand a little bit of where privacy laws are coming from, or as my very learned lawyer colleagues call underpinnings. So there's the Constitution of Canada, and there's this division of powers between provinces that always has to be taken into account. So what can provinces regulate or territories versus what the federal level can regulate? There's the Charter of Rights and Freedoms, where there is a note or a mention of privacy, not using the words privacy, but freedom. There's international agreements and standards, which I'm going to go over very briefly. Legislation and common law. Canada's being governed by common law, or that, except for Quebec, the province of Quebec. And then little things like retention periods, record keeping, litigation, which is a very low, subdued topic compared to the United States, and competition law. Because lately, you asked a question earlier about antitrust, but there's also, there's competition law as well involved, and there is a case in Canada I'm going to go over very briefly. So just so you have an idea that all of this creates a mesh of maybe inputs for privacy law in Canada. And now the small text, which I'm going to make sense of, because this is about for 2 lectures in my course, one of my courses. So Canadian law of privacy is a relatively new idea, because Canada has been governing itself under English common law, which I was in a webinar a couple of days ago presented by Max Schrems, and he said, oh boy, I had no idea what common law is like and what does it mean in court. So it's different. So the ideas in common law stem from this protection of liberty, invasion of privacy, peeping toms, where people can enjoy their property, and that was covered, but there wasn't anything separate that pointed out these rights to privacy. And of course, we have the international side of things, which also influence what's happening in Canada. So if we divide it up, there's the public sector, the private sector. Public sector, they've enacted their laws in the 1980s, and these laws are, for the federal level, is the Privacy Act, but the Privacy Act is kind of governed by 2 separate entities. One is the Office of the Privacy Commissioner of Canada, that looks into complaints against how the Privacy Act is applied in federal institutions in terms of protection of privacy rights in the federal agencies. But there's also the Information Commissioner of Canada that looks at access requests. So it's a separate entity. Both of these entities report directly to the House of Commons, and they have different mandates and different roles. But for you to understand, because we're going to come soon to, Canada has an adequacy decision under the directive. So before GDPR, you need to understand that while the legislative landscape is a bit fragmented. The coverage and the I guess the ombudsman model and the way we can access our rights in terms of privacy is very well established and very well trusted in Canada. So private sector laws enacted in the 1990s with Quebec leading the way. Quebec is still leading the way. I'm going to talk a little bit about that. In 1996, the Model Code for Protection of Personal Information gets published, where basically we establish a national voluntary standard. So it's a code of conduct for privacy, which included the 10 FIPS, the 10 principles. So PIPEDA was implemented in phases in 2001 starting and having full effect in 2004. And this is because there had to be ways to allow provinces to regulate the businesses that are provincial and not federally registered. So again, this is a little bit of the landscape and constitution in Canada. In the public sector, the law is not consent-based, but rather than limiting or looking at the purpose for collection and limiting the use, whereas in the private sector, the law is consent-based. However, at the federal level, there are some exceptions. So I'm not going to go into that because, like I said, that's a 4 to 6 hour lecture. But what you need to know is that certain provinces have their own private sector. That's British Columbia and Alberta. And they also regulate employment. So employment privacy is not regulated everywhere. Then in 2013, a different institution introduced the anti-spam legislation, which is a very, very strong and feared legislation. The word that I hear the most is draconian, which is the electronic communications. And that's the Canada Radio Television Commission that is regulating that. And then we have the health privacy. If you remember the quiz, there's the health privacy laws that have been adopted by different provinces, starting with Manitoba in very early 1997. And then we have Alberta and British Columbia leading the way, and Ontario PHIPA. Those have been, Ontario PHIPA has been revised to add certain more strict requirements, and they all require breach notification. And that's what's another, I guess, distinction is that not all of the laws, the privacy laws, even sectoral, mandate breach notification. So that's something we also have to be mindful of in Canada. Employee privacy, Quebec leading the way with Alberta and BC. And then there's this concept of harm, which again has been recognized through the tort of intrusion upon seclusion. I have to practice legal speak, which was introduced in 2012 in the Court of Appeal in Ontario, because of a case that happened and where there was a gap in how damages or harm was recognized from privacy intrusions. And that was in an employment context. What it means is that, and just to make it very simple, which is not, in Canada, the burden of harm is a lot lower to prove that than a lot of the states in the United States. That's evolving as well, and I'm really glad you had my colleague before to explain the legislative mesh in the United States. It's very complicated, and it's very complex as well. But anyway, privacy harms don't need to be proven. There are some thresholds where the possibility of harm can be identified and recognized. And again, some breach notification laws, which I have some charts for you. As you can see, I'm more into compliance, so you'll see a lot of charts, not a lot of law explanation. Data transfers to other jurisdictions is only prohibited by 2 provinces. That's in British Columbia, New Brunswick, and they are in the public sector. And so in the government, for the government employees, and I believe it's in the health sector. So the data of these employees cannot leave Canada, but otherwise, PIPEDA says that, you know, where there's adequate measure or similar equivalent measures of protection, and again, don't quote me, but that's the gist of it in the law, then the data can flow freely. We also subscribe to, of course, the OECD, and in the recent trade agreement between Canada, US, and Mexico, which is called USMCA, we call it NAFTA 2.0, so it's a free trade agreement. I was looking earlier, there is a specific provision on personal information for digital trade, so digital assets trade, where finally in 2020, in July, there has been something written in an agreement between US and Canada where it says the privacy of individuals from Canada will be protected and respected, and all these 3 countries will adhere to the principles of OECD. Which didn't happen before 2020, and it was very difficult for our privacy commissioners to reach into the United States and enforce any kind of privacy-related relief. To that point, the Privacy Commissioner of Canada has been busy. Their office has investigated Facebook, and they have very limited powers in terms of not in terms of enforcement, but more in terms of punishments, if you like. So the Competition Law Bureau in Canada actually took the lead. They teamed up with the Privacy Commissioner's Office, and they awarded some never heard of fine of $20-some million to Facebook for its different violations. Of course, we've gone after, or their Office of Privacy Commissioner of Canada gone after Equifax. Equifax is a credit rating agency that has had a massive breach in the United States. And there's been some turmoil there with how the Canadian breach accounts would be treated, and what kind of relief would be given to Canadians, given there was no kind of obligation written between the 2 countries. And as you can see, those are complications, as well as Clearview AI has been under investigation. So I was hearing from our Australian colleague, we kind of had the same investigations, which tells you that our privacy commissioners are connected. Canada has been always seen as a very active, at the forefront, as you remember, and I will never let you forget the privacy by design concept that was born in Canada. So there's a lot of respect for privacy in Canada, even though it's at the moment, with the PIPEDA being 20 years old, it's quite voluntary, if you like, in many ways. There is a lot of respect for privacy, and companies are actually very active in recognizing that privacy and data protection need to be top of mind. The last thing I want to talk to you about here, just looking at the time, is the GINA. And we like girls' names. Genetic Anti-Discrimination Act, that was recognized under federal jurisdiction. It was actually, there was a court action to say that, no, it shouldn't be federally regulated. You don't need to know about that, but that's a really big step for Genetic Anti-Discrimination Canada, and that the fact that it's federally regulated sets the tone of the kind of the regime and the protection overall in Canada as it is to be perceived. Just a little bit of where we have breach notification laws, as you can see by province or territory. It's mostly public sector, except you see Quebec. But there's health, based on the Health Information Act, those are always reportable breaches. And the federal at the bottom, finally in 2018, there's been an amendment that now asks organizations that fall under this act federally regulated to actually report breaches. This is, I don't think you can see it very clearly, a really great map of the world with different legislation introduced by KPMG in 2020, just so you can see a bit the evolution, right? So you can see that US at the federal level, they were, you know, starting to introduce CCPA, and then other laws came into the playing field recently, Virginia, Colorado, and so on. And then Canada was kind of struggling with this old law, PIPEDA. And then we had Brazil was starting to bring into force their LGPD law. China was just in the movement, and then they passed their PIPL law before Canada could pass a revised privacy law. So that's kind of the landscape. As you, like I said, privacy commissioners are watching. They all know what's going on. Canada is blessed to have this adequacy decision, which means free flow of data between the EU and Canada. And then I'm just going to bring in the bad news. So so PIPEDA, the federal law, needs to be amended because it does not include, we celebrate Data Privacy Day and not Data Protection Day in Canada because we lack a lot of the rights in the law that make it focused on data protection. So we can do access requests, but we cannot do a lot of the other rights that are under the GDPR law. This is why Canada needs to step up. However, the way the law is enforced in the guidance actually does permit a lot of these data protection rights to be recognized and enforced. So that's just a little bit of but. Just two quick things. The federal government tried to introduce a bill to modernize PIPEDA. It died on the vine before the election, so now we have no other bill. So Bill C11 is dead. Quebec introduced their Bill 64, which was approved right before the elections. We're very proud of them. Everyone in their parliament there just said, we got to pass this. This is important. So because the Quebec law was incredibly old, talked about paper files, and they introduced this protection of personal information in the public sector law, very similar to GDPR, very strict, with data transfer attention. In the law, it is required that people complete PIAs for the data to see if it's transferred outside of Quebec and what are the safeguards. So it's a very comprehensive law. And Alberta and British Columbia are also struggling. They're trying to improve their laws, and they've submitted improvements. So just so you kind of see the landscape there, where we're going with this is that we're seeing in the Canadian landscape an increased accountability, especially in the Quebec law. The CEO is actually responsible. So there's actually very strong enforcement, and it's being taken very seriously. So privacy and security, part of corporate liability. A breach of contractual obligations are, again, very seriously looked at. The effort in Canada now is all about vendor third-party risks. So the regulators also want more powers because they have very limited, they have to go to court, or it's very hard for them to even enforce fines. They, of course, come in and explain how to correct things, but they can't take things much further. And then just a little bit of visuals here, because my company's been doing a lot of work in creating all kinds of explaining, how do you navigate 20, 30 laws at a time or more? And I will tell you how by framework, by risk, by industry, by framework, and you look at, what does GDPR say, and then what are the other obligations? This will give you an idea. We've done a study on 14 frameworks that I actually know very, very well. and we place them in the different industry quadrants so you can understand kind of where you should be working with what framework. It is very difficult to enforce so many laws that you apply, even 5 or 6. You have to put them on the same page. And really, in the end, it's about the controls that you're going to implement to properly protect personal information. So we recommend that in Canada, you do privacy by framework. Here's some, just to give you a bit of a headache in the morning, just some frameworks that are in the public sector. We have our IRS equivalent, Canada Revenue Agency. We have Connecting Ontario, which is in my province. They have a public sector e-health kind of health framework. These are all frameworks. Of course, the Getting Accountability Right with the Privacy Management Program, which was kind of the first paper introduced by 3 privacy commissioners in Canada that spelled out accountability as a principle and how that can be turned into a privacy management program. I think there was one that was very interesting, this private sector privacy risk management framework that was introduced by the Privacy Commissioner of Ontario. So there's various attention to detail and trying to help public sector and businesses to make sense of how to implement a privacy management program. Last but not least, this is an interesting framework called the Pan-Canadian Trust Framework. So it doesn't talk about privacy in particular. And like I said, we are at the intersection of so many other initiatives, but this is really about digital identity and how government shares, different government agency could share information about us, the citizens, right? And of course, it's based upon other work like United Nations Commissions on International Trade. So we're looking everywhere around the world, but we're making our own recipes as well, but with that input. And I'm gonna kind of leave it there. That's the end of my presentation.
Thank you very much, Amalia, and it's great to see you again online. We met in London in 2017.
Yes, that's right. You were familiar to me. Yes, we did.
yes, we met at one of the IAPP conferences back yeah. in London, and I know that we shared a lot of thoughts about legislation in Canada and the GDPR. Yes, actually, Canada is the first non-EU country that got the adequacy decision back in 2001. If you can imagine, it was a decision based on the former directive. And I was wondering, it seems a little bit difficult that you have so many privacy sectoral legislation, right? And it would be possible at one moment to have in Canada something like a federal legislation that would include all these sectorial legislations. Would be easier for companies.
So that's the thought again around modernizing PIPEDA, so that PIPEDA can actually fully address employment privacy, fully address health privacy. However, allowing provinces to regulate their own sectors. So this is the struggle, but in the proposed Bill C-11, there were some 2 positive elements. One was about a lot more data protection rights that were outlined, and the second was that it was way more comprehensive. And some of us are saying, and political parties need to be part of, they seem to fall by the wayside, which is not a good idea. So yes, I believe there is a lot of work underway to modernize PIPEDA in a way that it does cover a lot of these. So there's not so many little gaps that we have to scratch our heads and see how we can bridge them.
Is there something that, in your opinion, you would not like that PIPEDA gets from the GDPR? Is that something that, in your opinion, something is not, I don't know, I give you just an example, the one-stop shop mechanism, right? In the EU might be or might not be applicable across Canada, depending on the state's legislation and so on. Or another example, for example, in the GDPR, the member states can set up the children's age in terms of consent when it comes to ISS, right? Is there something that you would really like to be in PIPEDA, or is there something that you would really like not to be there, like something on a negative and on a positive tone with the GDPR?
So I know one of the things that for me is very strange is this idea of consent in an era where notice and choice is so poorly written and managed and deployed out there. Where we have technology that is way ahead of these concepts. How are we going to make consent work in a world where consent happens every second or millisecond? In fact, it doesn't happen, but the world has to function. So how are we going to do that? So I'd like to see something in this new modernized law that addresses a little bit this conundrum, where how can consent be achieved, or is there a consent 2.0 that we have to think about? Another thing that somebody pointed out before me, not just in this session, was Japan. We don't have the notion of controller and processor. However, that's how we talk with our clients in Canada. So we'd like to see that addressed, because it's very important to even know what to call them. You know, the governing organization or the controller.
Outsource C.
Yeah.
Outsource C. I've seen this concept
or the exporter. I mean, to me, that just makes total nonsense for privacy. But yeah, those are a couple of things that come to mind.
I see. Yeah, in the recent EU-South Korea adequacy decision, the Commission is calling the entity which is instructed to process data by a controller outsource C. So basically, they are outsourcing their activities. But it's strange that this outsource is only within the national, only within South Korea. If it goes outside Korea, it becomes a third party, a data importer. Yeah, so it's very interesting. Amalia, thank you very much for your kind introduction on all the privacy sectorial legislation in Canada. Thank you very much. Mulțumesc frumos for being today with us. We will continue to have a look on the Canadian developments. All the best, and thank you for accepting our kind invitation.
Thank you. Mulțumesc și eu. All the best. Bye.
Dear viewers, dear audience, we will go now directly to Argentina, and I would like to introduce our next speaker, Diego Fernandez, who is a partner at Marval, O'Farrell and Merrill company. He's also an IAPP co-chair at the Buenos Aires KnowledgeNet chapter. On this way, we say hello to everyone in the team from the Romanian KnowledgeNet chapter. Diego is a partner in the IT and Privacy Practice Group. He's a technology expert with more than 16 years of experience with a wide range of expertise, which includes privacy and data protection. He is a former foreign associate in the IT and Privacy Group at Foley Ladder in Chicago, the US. Diego is a member of the Executive Committee of iTechLaw. He is also a member of the Education Advisory Committee of IAPP Board, and as I said, the co-chair of the IAPP Argentina chapter. Diego also teaches data protection legislation at Universidad de Tela on a course directed primarily to the C-suite level. He's also a professor at the John Marshall Law School in Chicago, the US. Now, Diego, the floor is yours, and thank you very much for being here in this international trip on privacy and data protection across the globe. The floor is yours.
Thank you, Sebastian, and feel free to interrupt me at any time if you have any questions, or if I'm going in the wrong direction. So I'm very happy to hear, very happy to accept the invitation of the association, very happy to share some of my thoughts. As Sebastian said, we are traveling all the way from Canada on the top north, all the way to Argentina. That if you were looking at the map that Amalia was displaying on the screen, Argentina is all the way on the south, so we are in summer here, for those of you suffering of cold. The idea is to share a little bit about the landscape in Argentina, what type of data protection legislation we have, and what has been happening during the last, I would say, 20 years. And that's what I'm going to try to do, going through different aspects of our regulation. And the good thing is, it was not on purpose, I think, but I'm coming after Canada that has a very different type of landscape for what we will be discussing. So Argentina, it's a federal country. It's divided. We have the national government, and then we have the provinces. And we do have a federal, we call it here in Argentina, a national data protection law, which in most aspects apply to any territory of Argentina, provided that you are processing personal data of those protected under the law, which normally are those who have a domicile in an address in Argentina. And so before having a data protection law that was enacted 20 years ago, so it has a long run, at least for Latin America. Data protection is a constitutional right, so it's recognized in our constitution. And also, for some time now, Argentina is a party to Convention 108, and it's pending the ratification before Congress of Convention 108 plus. So we also are part of these international treaties that kind of give a plain level for data protection around the world. So as I was saying, there are certain aspects of the law that are not applicable to other provinces, for example, because they are, of course, welcome to adhere to the different aspects. Those mainly are it has to do with sanctions and fines, which each province can enact its own regulation in that respect, and also the regulation of the specific proceeding, the judicial proceeding for enforcing the privacy rights. Otherwise, most of the sections of the law result applicable. And then on top of our data protection law, we have a decree, a regulatory decree that further regulates certain aspects of the law. And on top of that, we have the specific regulations of our data protection agency. In the case of Argentina, as I know some other countries have a similar approach, the Data Protection Authority is the agency of access to public information. So basically, they have two different directorates. One has to do with access to public information, and the other one with the protection of personal data. And this has been so for the last, I would say, 4 years. And I think it's sometimes it's a good resource, because in many cases we see that you have some tension between the access to personal data and the access to public information. And so when you have that and it's being heard by the same authority, you have a recourse on the top of the head of the agency to reconcile which, in specific case, which of those rights should prevail. The bad news is that it's been, I think, almost 2 years now that we do not have a head of the agency. The prior head resigned 2 years ago, and since then we have not been able to appoint a new head. So we don't have it established yet. So unlike Canada, Argentina has a general law. We don't have sectorial laws in principle. It's a general law applying to any sector of the industry. It also applies to public and private sectors on the same. And as I was saying, it has been inspired. This is connected to what Amelia was saying. It is inspired by the EU directive, and more specifically, mainly because of the language. If you're not familiar with Argentina, we speak Spanish here. It was inspired by the Spanish data protection law. And so 2 years after Canada, Argentina was also recognized as an adequate country for the protection of personal data out of the EU. and that, at least in our country, was something very, I would say, something very, very beneficial for some time, because then we do have Uruguay now as an adequate country. It brought business to the region, because at that time you were seeing many call centers or data centers flourishing around the world, and so many companies in the EU decided to have their call centers or data centers in Argentina, mainly because we were an adequate country, and so you needed no extra safeguards on top of anything you have in the EU. So that was something at that time was very important. As in the case of Canada, our adequacy decision was based on the directive. This means that since 2 years ago, Argentina is going through process of analysis of whether we are still adequate, or we should be considered an adequate country under GDPR. And I know this is kind of it's not a very public process, but we do know that our foreign ministry is in touch with the EU Commission, and through the agency they are discussing, they are asking questions about our law, and not only the law as it's drafted, mainly the practices that we have in Argentina, how the DPA analyzes the case, if the sanctions, whether security agencies in Argentina have a right to access to personal data, similar to the Schrems case, if you want. And so it is expected that in the near future, we don't have certainty when, there should be a decision on whether Argentina is still an adequate country or not. We, and myself, think that there are the circumstances of this case should show that Argentina is still an adequate country based on the data protection law, which is a 20-year data protection law, but it's still a very good law, in my opinion. Together with the further regulations over time by the DPA, I think, and we will get to that point where I will point out what differences we have to the GDPR, but we should still be an adequate country. On what else could I share with you? So we do have, unlike many countries, we still have a registration of databases requirement. So any database in Argentina which a data controller is processing should be registered before the Data Protection Authority. It's just a sworn declaration of what the database contains and what type of processing you are doing. I will also get to that next, as pointing out if it was worth or not during the time. And then, not surprisingly, we follow many of the general principles of data protection around the world. Mainly, I would say that the most important, maybe in Argentina, would be that we are an opt-in country. So consent is the legal basis for processing data. This consent has to be prior, express, informed, and in writing. This in writing, of course, over time has come to be a click-through, of course, online. But that is the general principle and the legal basis for processing personal data. We have exceptions to consent, but for the time being, we do not have other legal basis as you could have under GDPR, like legitimate interest or the need for a contractual relationship. We do have an exception. So as any exceptions, they should be interpreted restrictively. So if you are doing business in Argentina, you would probably want to make sure that if you are resorting to an exception, you have all necessary anything that is necessary to prove that you are rightly using that exception. As to general principles, we also have in our law the minimization principle as one of the most important, the purpose limitation, which is very, very important nowadays, I would say, and it was very important during the pandemic of COVID that we are going through. Again, the proportionality, what type of data we are collecting for different purposes, they have to be proportionate to this purpose. we have regulations and principles in terms of retention of personal data. You cannot retain personal data for longer than necessary for the purpose for it was collected. Of course, as in many other countries, you have to reconcile this principle with other regulations. You can have, for example, tax regulations that demand you to retain certain data, or even corporate regulations, labor regulations, etc. And then we have security principles. Basically, we have something very similar to the EU directive, in terms of having adequate or reasonable measures to protect the confidentiality and the security of personal data. In terms of international transfer, which is something that is very important, there's no way, or there are no businesses that do not need to make any transfer of data, unless for hosting. It's very common in Argentina to hire the services of hosting providers in the US mainly. And so our general principle, which would not surprise any of you, is that we cannot transfer personal data to jurisdictions that do not have an adequate level of protection. That's the general principle. Of course, there are two ways in which we can do it anyway, which are the consent of the data subject, or using, like in the EU, contractual clauses, model clauses, or resorting to binding corporate rules if the companies are of the same group. And related to that, we do have, in terms of contractual clauses, we have a regulation from the DPA of 2016, which mainly it brought two things. It approved two set of model clauses, one for a controller-controller relationship and one for a controller-processor relationship, which we have been using for a very long time now. And then it provided a wide list of adequate countries, which, not surprise, are the same countries that were approved by the EU. And so I would say, with the exception of the UK after Brexit, filed a formal petition before the DPA in Argentina, asking to be recognized as an adequate country, which the DPA accepted. And following the news from the EU, I've seen that in the last week or Korea was recognized as an adequate country. So it's probably that we will be following in the coming months, or I would say during the year. I said that Argentina is primarily an opt-in country, but we do have two very important exceptions to that, which are two opt-out mechanisms. One is the marketing communication. So collecting and processing personal data for marketing communications has an opt-out mechanism. You can actually send a marketing communication, provided that you give the data subject the possibility to opt out, and then you have to remove them from your mailing list. That's one. And the other one, which is very related to that, is we do have something that is called the do not call registry. So basically, you can sign up in a registry, so that companies providing services or doing marketing over the phone or email, they do not reach out to you. So the companies have an obligation to review that list once, I would say once every 2 months. And so it's an opt-out also. If you do not sign up on that list, then anyone can reach out to you. In terms of sanctions, that is, I would say, one of the weakest points that we have. The fines, in terms of monetary fines, the maximum that we have are $50,000 US, which of course has not been playing an active role to be a deterrent to comply with the data protection law. That's something that we think what we have to improve. We have to give better teeth to the authority if we want more compliance. And then something that has played I think an important role is because we do not have very, very severe fines. We do have a registry where every infringer of the law is included. And so that has played some important role in terms of, for example, M&A transactions. So if the company that's being acquired is on the registry, that is something that has played a role, and sometimes it has played a role to lower the price of the transactions. No one wants to be on that list. And so I think it has been very important. I was asked also to touch upon what, in my opinion, did not work perfectly well during the last 20 years. I wrote 3 or 4 of them. The first one is the registration of the databases. The idea of the registration, at least how those who participated in the drafting of the law said, is that it would give 2 things. It would be the DPA an idea of what kind of databases we had in Argentina and what type of processing of data we had. And then it will give, or it would elevate the protection of data of data subjects. And so 2 years ago, when the DPA drafted a new bill to replace the actual data protection law with a more GDPR approach, one of the reasons they were included in the draft was that this registration did not meet the expectations. And so it was removed from the draft, and Argentina was going towards a more accountability, if you want, in terms of data protection. The other one is the processing of health data, of sensitive data, health data for the development of the health tech industry. For many years, there have been a lot of debate about how sensitive data and health data could be processed by private parties, if consent was enough or not, etc. And that, I think, was a barrier for many companies to develop health tech solutions in Argentina, which are now a little bit more developed. Another thing that didn't work, and I told you before, are the low fines, which was, as I said, it was not a deterrent many times to comply with the law. It's very common that if you have someone asking what the regulatory framework is, and you go through it and you explain everything that they have to do, and then they ask, what if I don't? And you come up with a fine which is very low. There could be a temptation in some cases not to comply with the law. That's what I'm trying to say. And then, and I think this is something that is common around different countries in Latin America. The Data Protection Authority, of course, have limited resources. That's something that happens in our region. And because of the limited resources, they cannot be chasing as many cases as they want, and imposing the fines that correspond in those cases. As to the difference with GDPR, and I can kind of conclude with this my presentation. I see Sebastian on the screen again, so that might mean that I'm getting to the end of my time. So what difference we see with the data protection law, with the current data protection law? One is we do not have an express obligation to notify security incidents either to the DPA or data subjects, although it is recommended in different resolutions and further regulation from the DPA. And again, there are general principles of law that may suggest that in certain cases, it is a good idea or even mandatory to notify. We do not have an express need to appoint a DPO, although in the public sector, there are recommendations for public agencies to have one. Argentina still doesn't have an obligation on that respect. We do have the registration of the databases, I was saying, which is different. We have low fines, which it's very different to what you have under GDPR. And I would say that we don't have an accountability principle in general. There are certain regulations that seem to go toward that direction, but for the time being, accountability as such is not recognized. I would add maybe also portability. The portability right of data subject is also not recognized under our law. And that was something that was discussed and included in the draft that did not progress so far. So that is, in a nutshell, what I would like to share, Sebastian, about Argentina. I'm open to any questions now or in the future. And again, thank you very much for the invitation.
Muchas gracias, Señor Diego, for your kind overview over Argentina and over the efforts to change some part of the legislation, to be more aligned with the GDPR. Indeed, it's true that Argentina was the second non-EU country to receive the adequacy decision after Canada. So we were lucky that Argentina was right after the part of Amalia from Canada. I would like to ask you something interesting. You said that you are transferring data like to the US for hosting providers, right? In the US. So it means that at this moment, Argentina considers that the US provides an adequate level of data protection, right? And I was wondering if do you know, or if in your opinion, do you think that data from EU citizens or data from the Union or from the EEA, which is transferred based on the adequacy decision to Argentina, might also end up in the US, so might also be subject to an onward transfer to the US to end up in the hosting providers servers from the US.
Yeah, so no, I have to clarify there, Sebastian. Argentina does not consider the US as an adequate country. We transfer data to the US mainly on data transfer agreements using the model clauses that has been approved by the DPA. I would say that the biggest four service provider in the US, AWS, Microsoft, etc., they incorporate the model clauses in their contracts with the Argentine companies. So we do not, in principle, I would say, we normally transfer data on the basis of either consent of the data subject or a DTA with the service provider. So no, in the case you were referring, if we were receiving data from the EU and then transferring that to the US, that would be a huge problem for the data controller, of course.
And as you correctly mentioned, there are ongoing discussions for the review of the adequacy decision, for the review of the adequacy decision with Argentina, but also with all the other countries that received adequacy decision based on the directive. Do you think that there should be some changes in the Argentinian legislation to be sure that Argentina will continue to have the adequacy decision also under the GDPR? Because you were mentioning that there are no obligations for data breaches. There is no one express need to appoint a DPO. There are low fines. So maybe some aspects might be heavy when the EU will choose to continue or not the adequacy decision with Argentina.
Yeah, that is correct. I would, my opinion, and this is very personal, I would say that the spirit and the general principles of GDPR are respected by the Argentine data protection law, still with no changes. But if you want to be on the safe side, of course, it would be a good idea, as Uruguay, for example, did. Uruguay is our neighbor here, and it's an adequate country, which rushed after GDPR and they amended the law and they included some of the things. So I would say that if we can pass new legislation with the security incident, the DPO, and all the other things I was mentioning, that would put us in a very safe place. But still, with no changes, my opinion is that the spirit and the most important principles are respected, and there would be reasonable reasons to have Argentina confirmed as an adequate country. We will see if they share our views. I have not been consulted, Sebastian, but I will be happy to appear before the Commission.
Let's hope for the best, and let's hope that Argentina will continue to have an adequacy decision based on the GDPR as well. Thank you very much, Diego, for being with us today, and we wish you all the best all the way from Romania to Argentina. And thank you very much for accepting our invitation.
Thank you. Bye-bye.
I will now introduce our next speaker, Mr. Nicola Fabiano, who is an Italian lawyer representing clients in front of Italian high courts, civil law specialist, independent researcher, and a frequent speaker at international conferences on data protection, privacy, cybersecurity, IoT, and blockchain. I would like to highlight that Nicola Fabiano is the former president of the San Marino Data Protection Authority, and he had a mandate for 2 years between 2019 and 2021. He is a renowned expert for the Republic of San Marino in the Consultative Committee of the Council of Europe on the Convention for Data Protection, Convention 108. He is also a member of the Ad hoc Committee on Artificial Intelligence, CAHAI, of the Council of Europe. He has also been part of the government. He has been an advisor of the government of the Republic of San Marino, and he's the creator of the data protection and privacy relationship model dpo-NET.ro, based on a high mathematics and set theory. He is also the president of the Center of Informatics and Forensic Innovation, CIN4, in Italy, and has many security certifications, such as certification for data protection officer or the information security management for systems professionals, the ISO 27021. We are very happy to have Mr. Nicola Fabiano here today to talk a little bit about his vast experience on the DPA activity of San Marino, and also to join this international trip. Nicola Fabiano, thank you very much for joining us, and thank you very much for joining our international trip. Our next stop is in Italy. The floor is yours. Thank you.
Thank you very much, Sebastian. Good afternoon, good morning, good evening, everyone. Thank you very much for the invitation. I much appreciate it. It's an honor for me to participate in this very high-level event together with other authoritative panelists. I will share with you some thoughts about my experience and my researches. As you probably know, I was also, Sebastian already told this, I was the first president of the first data protection authority of the Republic of San Marino. For those who don't know San Marino, I say that San Marino is a small republic on the Taitano mountain. There are 35,000 inhabitants. The singular characteristic is that San Marino is a state inside another state, which is Italy. What's happened in 2017, and precisely from November 2017 to April 2018, the government of the Republic of San Marino appointed me as an advisor for drafting the legislation on the protection of personal data. I prepared the draft and delivered it to the government in April 2018. In December 2018, the Parliament approved the draft that became the law on the protection of natural person with regard to the processing of personal data, which is Law 171/2018. It was the first law on the protection of natural persons with regard to the processing of personal data, GDPR-oriented, in the Republic of San Marino. Consequently, the San Marino DPA has been set up just by Law 171/2018. The collegiate body took office on 4 April 2019, and it is composed of 3 members, a president, a vice president, and a member. Generally speaking, I summarize my view, even adopted during my institutional role as president of the San Marino DPA, in 3 points. First, taking care of the domestic scenario by being always available for any issue. Mainly, I was, as I always am, available to receive people by whom to listen and with whom discuss any issue. Never I was unavailable for people. Second, building and growing international relationships and cooperation with other DPA. Third, paying attention to innovative phenomena and high technologies development, not censoring them, but evaluating the impact on natural persons and personal data. Indeed, the DPA became a member of GPA, formerly ICDPPC, in October 2019 during the 41st conference in Tirana. However, in July last year, in July 2021, the government of the Republic of San Marino decided to modify the law in force on the protection of natural persons with regard to the processing of personal data. I strongly disagreed with that modification that, in my view, undermined some general data protection principles and particularly independence. Thus, I communicated my view to the government. Unfortunately, the government decided to adopt and approve the modification to the law. So I resigned from my office as President of the Republic of San Marino at the end of November. I am a coherent person and I respect all legal principles, particularly independence, because it is the pillar of a DPA. What should a privacy professional take into account? I highlight 3 points because 3 is the perfect number. First, to be aware of times changing. In my opinion, this is a fundamental point and at the same time, the main starting point. It means to be ready to address the challenges. Change of mentality is required. In my perspective, for a long time, all of us got into the new data protection and privacy era. Unfortunately, many people are not realizing it and continue dealing with data protection and privacy like it was in the past, some times ago. Actually, I don't know whether consciously or unconsciously. They don't get the changing. I don't discover the hot water now, but it's evident that today data protection and privacy require the newest vision and attitude. We can deal correctly with data protection and privacy only if we are forward-looking, seeing far ahead our desk. It's a matter of approach, and we should try to change our mentality. We should be open-minded and change our habits, or better, our approach to the data protection and privacy domain. That requires a profound and radical change of mentality that does not mean not considering and or overlooking the privacy laws such as the GDPR, but to be aware that now we are facing a new privacy era. The GDPR is a revolution, and most of us struggle to enter the new data protection conceptual dimension. We might continue working on data protection and privacy with an obsolete and less fruitful approach and focused only on the norms, neglecting some other relevant and pertinent aspects. In this way, we will finish understanding a part only, but not the whole. I know that it's challenging to change the approach when one learned the principles and consequently adopt the same method for years. However, times change and we have to be aware of it. Second point, to be able to identify the challenges or have an idea of them. What are the challenges? We should be aware of the challenging. It's sufficient read some current news on the internet to understand what's happening. For example, I refer to the growing data traffic on the internet. We already know big data. Currently, the dimension is zettabytes. However, we continue referring to fewer magnitudes, almost as nothing was grown. In 2018, IBM made a forecast. In 2020, we would have reached 40 zettabytes, almost 43 trillion gigabytes. Now we are in 2022, and I am sure that people still ignore the current and future network traffic dimensions. The questions are, first, where is our mind pointing out? Second, what is our thinking about technical development? And consequently, third, what is our approach on the innovation impact on personal data and privacy? So we can identify the challenges of our time, of a today that is already tomorrow. 2 years ago, I created a model, and precisely the data protection and privacy relationships model. Its acronym is dpo-NET.ro. dpo-NET is a relationship model based on high mathematics and set theory, capable of being used in the times we live and in the future, because it helps privacy professionals, and not only, address any issue. The dpo-NET logo is what in mathematics is defined fiber bundle, where each intersection of the lines constitutes an object existing in our reality. Still, we probably do not see those objects or consider them in approaching and addressing privacy topics. Nowadays, we can highlight two issues to be tackled consciously, which fundamentally concern epidemiological and cyber risks. These are two significant areas that nevertheless show their weakness. On the one hand, in the inadequacy of infrastructures, and on the other, in need to develop effective procedures to deal with them. Sorry. Third, focus on the main challenges. The first is pandemic. Since 2020, we have continued living in a tough time due to the pandemic by COVID-19. Fortunately, it seems that the alarm decreased in the last months. Pandemic undoubtedly had effects on people's health, and we hope to defeat it soon. So the pandemic's harmful phenomenon has had a global impact, including primarily serious reflection on humanity's role and how much prevention is a priority. I think that it has also led to an awareness of the consideration of human value. Still, we can consider it even a challenge. On the one hand, the pandemic has obliged all of us to increase the use of digital services and resources. On the other hand, it forced us to deepen whether the solutions are compliant with data protection and privacy laws. Indeed, the pandemic has shown that communication between humans is essential. Indeed, communication has changed, but why do people continue using specific apps? I refer to WhatsApp, Signal, and Telegram. The whereas number 7 of the GDPR says natural persons should have control of their own personal data. Legal and practical certainty for natural persons, economic operators, and public authorities should be enhanced. Despite the GDPR norms, and whereas I mentioned, people don't care about that principle and continue using, for example, WhatsApp for work. Sincerely, it's worrying. I wrote several contributions on this topic and I don't use WhatsApp for almost a year. However, I continue to have some troubles, although after several requests, WhatsApp told me that nothing more is possible doing because they have deleted my account. Do you know why? People I exchanged messages with WhatsApp continue viewing my profile just like I'm still an active user. I leave you to imagine what a sad scenario is. As a privacy professional, it is frustrating to live in situations when a data subject cannot exercise control over their personal data. The conclusion is that by using such technical solutions, we voluntarily choose to be victims without freedom of choice due to the power of control by some big player. But we can choose to communicate by different solutions or applications, contributing to building a concrete user-centric privacy domain. Indeed, we can opt for a solution like metrics or applications based on the XMPP protocol. Both are open protocol and the relative solutions are decentralized, distributed, and federated, guaranteeing the data subject to allow complete control over their data. I see, Sebastian, so I'm getting at the end of my time. There are already several tested experiences globally, and I will refer you to an appreciable initiative based on metrics that is the domain is safesupport.chart. We are privacy professionals and we have to analyze the issues that impact data protection and privacy. We have to highlight and discuss any possible issue. We cannot be shallow and allow everything to happen going over it. It isn't a call to war, but an invite to be ever more careful and rigorous. We have all of the instruments that are not only the laws, but even the convention. Bear in mind Convention 108 in the modernized version as Convention 108 Plus, the Charter of Fundamental Rights of the European Union, etc. We should be aware of how technical solutions impact natural persons and their personal information. We can instead communicate by controlling our personal data by choosing different solutions because there are. Any initiative to raise people's awareness of the risks related to their personal data is welcome. In the same way, we can decide not to use resources that are unclear regarding personal data. It's possible to do some work in alternative ways, smart working. It is not possible to give up services, including through platforms. In short, the state of health emergency has allowed us to have a confirmation that the internet is fundamental and almost indispensable resource. Furthermore, due to the pandemic, we had to study and discuss the solutions effect. I refer to the debate on the Green Pass. We know the joint opinion issued by the EDPS and the ADPB and the work in the States. There is the last third point, that is artificial intelligence, but I am afraid that I have not much time to present my view, so I can conclude now. I want to thank you very much.
Please go ahead. You
Oh,
still have 2-3 minutes on AI and data
thank
protection.
you.
We are
Thank you.
very eager.
Thank you so much. So the third challenge is artificial intelligence. From technology to artificial intelligence, the step is short. In Europe, we know the European Commission started working in 2018, appointing 52 experts to a high-level expert group on artificial intelligence. We know also that the Committee of Ministers of the Council of Europe in September 2019 set up an ad hoc committee on artificial intelligence named KAI. And in the last months, the number of contributions related to artificial intelligence and facial recognition increased. The aspects mentioned above and the growing interest in these topics show that we face crucial phenomena. Indeed, lastly, on 21st April 2021, the European Commission proposed new rules and actions aiming to turn Europe into the global hub for trustworthy artificial intelligence, presenting the well-known proposal. AI solutions are often parts of an Internet of Things ecosystem where it is essential to pay attention to data privacy and protection. Furthermore, it's crucial also to consider ethics as an integral and fundamental approach. We cannot prescinde from ethics, and we cannot forget it indeed. Apart from the technical solutions adopted or that should be adopted, the topics related to facial recognition and artificial intelligence have a very high impact on protecting personal data. It is worrying to read about facial recognition systems that work starting from information related to a human face, comparing them with other data as extracted from images existing on the web, and finally matching them to recognize a person. Artificial intelligence is now part of our existence. I appreciate and welcome the proposal of regulation carried out by the European Commission because it was a brave act to define artificial intelligence by law. Artificial intelligence is a broader field that it would be challenging to identify its perimeter, and I think that we will have to discuss it many times. We know that in Europe, we will have new legislation on artificial intelligence and new independent authorities to control this sector. What kind of effects on data protection and privacy in the worldwide context? Are we sure about the needing legislation on artificial intelligence, or do we probably only need to adopt a correct approach to face a solution using the current legal instrument we already have? My question derives from the consideration by which technical standards on robots and artificial intelligence already exist, and some others in due course of development or at the final stage. We can't risk that the technical domain prevails over the legal one. On the contrary, we should find the right balance to address artificial intelligence and achieve the proper goals of a DPA. It's relevant that any DPA has the same general criteria in this field. We should not forget that there are also risks about the misuse of AI, twisting the same AI and robotics toward computer weapons or lethal autonomous weapons systems. We should pay attention and be aware of them. Anyway, we should see that what will happen in Europe in the next few months in this domain. Still, just referring to data protection, we notice the many risk profiles that can seriously compromise individuals' fundamental rights and freedoms. So, in the current context, artificial intelligence is undoubtedly another of the challenges, so much so that national and international institutions have become aware of it and have expressed their position, especially about the protection of fundamental human rights. Thank you so much for your attention, for the time. So it's a very exciting experience to be here with you. I am also an IAPP privacy profession, an IAPP member, so it's for me an honor to be here today. Thank you so much.
Grazie a lei, Signor Fabiano. Thank you very much, Nicola, for being with us and for accepting our invitation. It is very interesting because you've been the head of an EEA DPA, right? Or EU DPA, let's put it like that. And you worked side by side with the changes for the legislation for San Marino. You are looking for the changes which would come from the EU in terms of maybe why not a review of the GDPR, but also the future AI regulation. And I was wondering, in your opinion, I have two questions. Who owns the data? It is us, or it's already the companies to whom we gave the data and they would monetize or they would do whatever they do with our data? And my second question would be regarding the future AI regulation. Do you think that this EU regulation should be supervised, enforced, and implemented by the national EU data protection authorities, or we should have another organism because the EU DPAs are already busy with implementing and enforcing the GDPR across the EU member states?
Thank you. Regarding the first question, are you referring to San Marino regarding who owned the personal data?
So, in your opinion, in general, who owns? Who? It's a general question. Who owns our personal data?
I believe, in my view, any natural person should have full control over their personal information, their personal data. And we, as a natural person, everyone should be aware about the risks related to using some particular applications. So, in my view, we should start awareness raising campaigns to aiming to spread the relevance of the value of the personal data value, because in my view, personal data is a value belonging to a natural person, and I consider personal data as an high value indeed, and deserve the attention as a fundamental right. The second question is in my view. So the proposal on the AE it's quite strange in my view, because at Article 3, the proposal define artificial intelligence as a software. So all of us, we are going around and around the definition of or trying to imagine on some particular scenarios related to artificial intelligence. But it's simple. Artificial intelligence is a software. So regarding the supervisory authority, I think that the control over any artificial intelligence activity, it depends on the kind of control, because if the control is related to personal information, so personal data, any data protection authority, any supervisory authority should carry out any activity related to artificial intelligence. But I seem that in Europe, I seem that there are rumors by which it seems that it will be necessary to set up a specific supervisory authority, an artificial intelligence supervisory authority. So I think that we have to wait the final step of this proposal to understand what is the political approach to this matter, and if the topic related to the control can remain in the domain of a distinct supervisory authority. I don't know. I seem that rumors are going towards a new supervisory authority, a specific supervisory authority that will deal with artificial intelligence properly.
Indeed, there are still ongoing discussions in Brussels between all the three legislative institutions, between the Council, the Commission, and the Parliament, and let's see what these discussions would bring up. Nicola Fabiano, thank you very much again. It was an honor to have you on our delightful list of speakers, and we wish you all the best. One last question, easy question from the audience: where we could find and read your papers? If you could give us the source, or maybe an email address, or a blog, or
in the last months of 2021, I studying the model dpo-NET.ro, I published the paper. An updated paper on dpo-NET has been published on an American journal. So if you are interested, I can send some information. The precise link to see and download the paper. However, on my LinkedIn profile or on my blog, there are several information about dpo-NET, or if you can try to www.dpo-NET.ru.
Okay, thank you very much. Thank you very much again, and we wish you a great afternoon.
My pleasure. You too. Thank you so much. All the best.
Thank you very much. And now, in our international trip, we are going all the way to Africa, to Ghana, and we say hello to Sharif Issa. Sharif Issa is a cybersecurity manager at Deloitte, and he works as an information security governance, risk and compliance professional, and a data privacy activist with more than 14 years of experience. His experience spans IT management, IT project management, business continuity, and information security. He is also subject matter expert for the EC Council and the Director of Communications for the Institute of ICT Professionals in Ghana. He holds various certifications, such as the PECB, is a certified CISO, payment card industry professional, and so on. He has also vast experience with consulting banks and experience on financial technology for companies across Africa, where he worked for implementing standards like ISO 27001 and 22301 and the PCI DSS. He's a columnist with several articles to his credit. He also spoken to other international conferences and other events, and is an honor to have you here. Sharif, welcome on board to this international trip, and please let us know how is the situation in Ghana regarding privacy, data protection, and legislation, and which are the challenges that you encounter the most in Ghana and across Africa. Thank you very much for being with
Okay,
us.
thank you, Sebastian, for having me. I also thank all our audience all over the world. And I must mention that before we delve deep into the discussion, I mean, all the submissions I'll be making on this conference, they are personal submissions and they have no relationship or anything to do with the organizations I am associated with. So in this presentation, we're going to look at basically data protection guidelines in Africa. We spent some few minutes in there, and also look at the Ghana Data Protection Act. Then also look at issues of compliance, few issues of compliance, the challenges that we have here. Then also look at the solutions we've attempted to put in place and the ones we're still working on, and also do a very little comparison in terms of the differences between the Ghana Data Protection Act and the EU GDPR. So when it comes to the African terrain, in June 2014, the African Union adopted the document, what we call the Convention on Cybersecurity and Personal Data Protection, aka the Malabo Convention. And it's basically a document that covers issues of electronic transaction, privacy, and cybersecurity. So as we speak, the convention has been ratified by only 10 out of the 54 sovereign countries. I mean, it's virtually less than 20% of all the countries in Africa. And at least Ghana, I mean, we're the fifth country to ratify in May 2019. Guinea has done that, Mauritius, Namibia, Senegal, Angola, Mozambique, Rwanda, and I think recently Togo also did. So the convention, or the Malabo Convention, has not come into force. The reason is that per the explanation of the convention, it's supposed to enter into force 30 days after the 15th ratification. So since we have 10 ratifications so far from 2014, it's still not in force. So I mean, it's a document sitting somewhere. We are praying that it will come into force by, I mean, the time you have our 15th ratification. So according to the UNCTAD, that's the UN Conference on Trade and Development, as of last month, that's December 2021, 54% of African countries, or countries in Africa, had working data privacy legislation. And 70% had draft legislation, which means they are not, enforceable, they are not enforced. Then 20% had no legislation at all. And according to UNCTAD, they couldn't get data on 9% of the countries in Africa. When it comes to legislation in Africa as a whole, the first country in Africa to have working data privacy legislation was Cape Verde. And most recently, that's Egypt in 2020. Cape Verde's own was in 2001 then. For Ghana, in the case of Ghana, our Data Protection Act, was enacted in 2012 and also came into force in 2012. The act primarily, we call it Act 843. The act primarily set out the rules and responsibilities governing the collection, use, disclosure, and care for personally identified information by data controllers and data processors. So the Act, the Data Protection Act, Act 843, establishes the Data Protection Commission, which is more or less like the regulatory body for data protection in Ghana. So the core aim of the DPC, or the Data Protection Commission, is to, ensure the implementation of the provisions of the Act, protecting data subjects, ensuring the data protection register is in place and updated as well as maintained. When it comes to compliance in Ghana, with regards to our Data Protection Act, our Act 843 is almost a decade old, but there are still some challenges we do have. But in order to ensure compliance to our Act 843, there are a number of things data controllers need to do. In line with Section 46 and 27 of the Act, all data controllers are supposed to register with the Data Protection Commission. This is to help maintain the Data Protection Register and also renew their registration every 2 years. After getting certified, you need to renew every 2 years. And data controllers are also supposed to appoint data protection supervisors. The EU will call it the DPO, but in Ghana we call it a DPS. So in line with Section 58 of our Data Protection Act 843, data controllers are supposed to appoint data protection supervisors and also train them as well. It's not only about appointment, but they need to be trained well to undertake their role. Then for organizations also need to conduct gap analysis to identify the shortfalls within their data privacy practices. Then also create and review policies, processes, and procedures related to data privacy. They're supposed to also train employees, very important. It cut across all jurisdiction when it comes to data protection. Then 8 is also to conduct compliance assessment or audit of their data privacy or data protection practices within the organization. So this is basically generally what data controllers are supposed to do. And according to the Registrar General of Ghana, our new company database has a total of about 524,000 registered companies, and it's looking at how far we've come, close to a decade, 9 years now, and looking at this 524,000 registered companies. We should be hopeful that we have a huge number of them registered, but in actual sense, that seems to be a challenge. In my own estimation, we have about less than 10% of these companies registered with the Data Protection Commission. Registration doesn't mean you are compliant, but it's the first step to compliance because it comes with some prerequisites that you need to fulfill. So looking at the vast difference in terms of the controllers who have registered and the total number of controllers on our register in terms of the company database seems to be very vast. Some of the challenges we have in Ghana, which may be obvious in other countries, it may not be peculiar to Ghana per se. Limited resources for the regulator to work. That's I would say, in my opinion, it's kind of a big challenge. Resources in terms of logistics, human, financial. Just mention them. That seems to be kind of a stumbling block to us. Let me put it this way. Then the second has to do with the initial registration process that was adopted by the commission. Initially, it used to be a manual process where you'll be given a form, you fill a very lengthy form, and also it was kind of cumbersome, but currently that has been sorted. Then thirdly, it has to do with the failure of the data controllers to register with the commission. As I earlier mentioned, you see, some of the big companies who, they are big giants. They are giants. In Ghana, who might not have even registered with the Data Protection Commission in the first place, or might not have even renewed their certification. Some may not even appoint data protection supervisors at all. If they appoint to, it's kind of they are playing conflicting roles. Some are not officially appointed. That seems to be the challenge we are having here, but we are hopeful that gradually things will get better. The fourth point has to do with inadequate data privacy awareness. Not that we are not doing anything about awareness, we are doing that, but it seems we seem to focus exert our energy more on when it comes to the Data Protection Day. That's 28th January of every year. We have big gatherings, talk, but it shouldn't end there. Of course, the commission also does some form of webinars, but I mean, if you put your eyes on the ground, put your ears on the ground, you get to know that the awareness is not hitting, I mean, the general public. You know, the general public, we are more like, we are the beneficiary of data protection regulations. So if we don't know our rights, how do we even demand our right from data controllers? That seems to be a challenge. And the final challenge we have has to do with weak enforcement regime from the regulator. As I mentioned earlier, I mean, looking at the percentage of organizations or data controllers who have registered with our Data Protection Commission, I mean, there's no need to crack the whip. If you're looking at compliance, I mean, coming from close to a decade, and looking at the percentage, in my estimation, there's the need to crack the whip. And I mean, there have been some major national issues which we thought the regulator could also crack the whip, and it seems that's I mean, it's out of authority though, but it seems it's want to be very, I mean, for want of a better word, careful about that, but we pray that things will be better. So I mean, looking at the issues, I mean, aforementioned, the commission has, I mean, it has done well in trying to mitigate some of these gaps. The first step it took was to acquire software, a web-based application that helps in registering the data controllers and also ensure compliance of these data controllers. It gives the data controllers the chance to create users and also assess their compliance based on the feedback they put in, the kind of information or the questionnaire they complete in the system, and give them the compliance status and also show them roadmap for compliance. So that's a very bold step and laudable step our regulator took in that space. Then the second also had to do with the data controllers who had not registered with the data protection were granted amnesty for about 6 months between 2020 and 2021 to allow them to register and pay only the current year's fee. So, I mean, that's also, a good strategy our regulator adopted in ensuring that more people register. Because, I mean, the first step to compliance is registration. So if you don't get people to register, you can't even engage them. You wouldn't even know of their existence. So that was a very, bold step. And I mean, in this same regard, in October 2020, 5 state institutions were presented with awards by the regulator, the Data Protection Commission, in recognition of their compliance with the Act. And mind you, in Ghana, we have about 400 state institutions, approximately 400 state institutions. And if we are awarding 5 of them, I mean, you can imagine all that means, the kind of work, the quantum of work we need to do in that respect. And thirdly, one of the things the Data Protection Commission, our regulator, has done is that it has collaborated with the Internal Audit Agency of Ghana to train all internal auditors to be able to audit data controllers against the requirements of the Act, the Data Protection Act. And it's also sometimes, I mentioned earlier, it's sometimes organized webinars to create awareness. So, I mean, this third point is also a very good thing we are doing here, just to ensure that, because I mean, once the regulation is implemented, there's a need to audit to give some form of assurance in there, and it's part of the requirement. So once the DPC is training the internal auditors, it's also, a good way to go in that respect. So I want to wrap up with I will call it the differences or the similarities between the General Data Protection Regulation, that's the EU GDPR, and the Act 843 of Ghana. You know, the privacy principles of the EU GDPR and Act 843, and maybe any other, data privacy regulation you can mention, They are similar. I mean, the privacy principles are similar to the 8 principles of the OECD privacy framework. So, I mean, in general, the Act 843 and GDPR in terms of privacy principles, there's not much, but I would say there's no difference. I mean, that is it. But when it comes to, I mean, differences, I mean, there are basically 2 major differences. One has to do with the scope of the application. You know, GDPR is applicable, I mean, globally. I mean, provided the data controller stores or processes PIs of EU citizens. But in the case of Ghana, according to Act 843, its application has to do with data controllers who are established in Ghana and process data in Ghana, or a data controller who is not established in Ghana but uses equipment or data processes in Ghana. And thirdly, a data controller who processes information originating partly or wholly from Ghana. The second difference I will say, which is significant, of course, there may be some minor differences, but these are the significant ones I want to touch on. What's the GDPR? I mean, in terms of notification, what's the GDPR as 72 hours notification period? Our Act 843, I mean, talks about giving reasonable and practical notification as soon as the event occurs or there's an incident. So that's the leeway. So it says it should be as soon as reasonably practicable. So it's kind of the lawyers will say there's a lacuna, but I mean, probably as we go forward and based on our experience, we'll try to, I mean, put things together to fine-tune this law. I must mention, I mean, there hasn't been any deliberate attempt as I speak to, I mean, make revisions to our Act 843. And I think, personally, I agree to that, because even what we have, enforcement hasn't been, I mean, that hasn't been significant, I must say. So it is supposed to be gradual. Make sure we put things in proper perspective and move in that direction. So in a nutshell, I would say there are more similarities in the GDPR and Act 843, our Data Protection Act, than there are differences. So Sebastian, thank you very much. Thank you.
Thank you very much, Sharif, for taking us in this great tour over the legislation in Ghana. And it's very, very great to hear that Ghana and the EU has implemented and has the same principles, and that Ghana adopted the principles from the OECD when it regards to processing personal data. And I was wondering, if tomorrow there would be a similar legislation as the GDPR in Ghana, which would be, let's say, 3 most positive things that you would like to see in Ghana, that you think that would work in Ghana, having regards the mentality of the companies there, and having regards the awareness for privacy and data protection, and which things you think that might not work if Ghana would implement a similar legislation to the GDPR, let's say tomorrow?
Okay, so I mean, more or less just opposing GDPR and our Data Protection Act. I would say in terms of, I mean, things to introduce, I think it's more like, I would say it's a sanction regime. I mean, that's what I see. If even, I mean, your regulation is not that robust, or it doesn't even have I mean, the key requirements. I mean, in terms of international best practice, I'm not saying that, but assuming, I mean, on that assumption, enforcement is a key. I mean, when there's no enforcement, nothing happens. So enforcement is I mean, is what the regulator need to, I mean, critically drive that. And also touching on the other side has to do with sanction. If you look at the sanctions in GDPR, if you bring it together, you cause a lot of mayhem. Of course, it may increase compliance, but it will be chaotic. In Ghana, when it comes to the penalties, you have up to about 5,000 penalty units, which is about 10,000 USD. That's a maximum penalty. A defaulter or someone who contravenes the act will pay. In terms of imprisonment, you have up to 10 years of imprisonment. It's punitive enough, but just that once the enforcement is low, nothing will happen. We are all trying our best in our own small ways. To make sure things work out for us.
So you would like to have more enforcement powers for the Ghanese Data Protection Authority, right? So, and more awareness as well, because if we have enforcement, we should also have awareness. People should know their rights. Companies should know their obligations. So maybe a change in culture towards a privacy culture might be needed. And this is very interesting because we hear the same conversation across the EU and also in some member states, and we hear that the discussions should shift towards a privacy culture, privacy by design, privacy by default, and it's very interesting that the same discussions would be also needed in Ghana. We have a question from the audience, and someone is asking you, how do African PDOs are working with special categories of personal data when it comes to cases transferring personal data to international companies, such as taxi services?
Okay, so as thank you for the question. As I earlier mentioned, of course, I cannot speak for the other African countries. For Ghana, when it comes to transfer, our act seems to be kind of quiet on that. It's kind of quiet on that. As I mentioned earlier, in terms of the applicability of our act, I mentioned 3 areas, which has to do with a data controller who is established in Ghana and processes data in Ghana, a data controller who is not established in Ghana but uses equipment or data processes in Ghana, or a data controller who processes information originating partly or wholly from Ghana. So in terms of transfer, it's not explicit. It's not explicit in there.
Okay, Sharif, thank you very much for your kind for accepting our kind invitation. Thank you very much for being here and helping us to understand more what's the situation in Ghana and what's the situation in Africa. We wish you all the best with the privacy awareness for the data subjects, because we all know that that's important. And we will keep an eye on the legislative developments in Ghana. Thank you very much for being with us.
Thank you for having me. Bye-bye.
Thank you very much. Now, from Ghana, in our international trip, we will go all the way to Russia, and we invite Alexei Muntian, who is a co-founder and board member of the Russian Privacy Professionals Association. He's a member of the Council for the Development of Anti-Corruption Compliance and Business Ethics at the Chamber of Commerce and Industry of the Russian Federation. Alexei is a data protection lawyer and has implemented more than 70 projects in the field of data protection and compliance. He has experience as a data protection officer at Johnson & Johnson, DHL Express, Alpha Group Consortium, Sberbank, CAB, at the Office of the UN High Commissioner for Human Rights, East Africa Regional Office. In 2010 and 2011, he provided content for the personal data portal of the Russian Data Protection Authority. He is also the consulting editor for the Russian translation of the guidelines on personal data protection in humanitarian action, prepared by the International Committee of the Red Cross and the Brussels Center for Privacy Research. Alexei, thank you very much for being with us today, and thank you very much for accepting our invitation for our international trip. The floor is yours.
Well, thanks a lot. Thanks for the invitation, and I'm really pleased to share some of my modest experience. So today I would like to show and tell about the privacy in Russia, and for sure. So I would like to make it maybe not only in words, but with some slides. So here is some information about myself. But of course, I can skip the slide because the all important information about myself was already pronounced. And just one thing that I would like to say that I'm really and true dedicated to data privacy, because it was my choice from the beginning. So from the 2003, when I decided to go to this really interesting part of our life, to part of data privacy. And of course, I'm really glad that now in 2022, really a big amount of people they're really interested in this profession. So, and because of that, so I'm really happy that I feeling that my choice was right, and that I'm really involved and providing really important things to other people. And of course, I would like to start with this deep dive in the Russian specifics, with just a small comparison with the data privacy laws. So here you can see maybe one of the main main points of the main bones of the skeleton of the data privacy laws. So we can see comparing the GDPR, Russia, Kazakhstan, and Georgia, just to show you what are the regional differences. And so if you can see, well, in main points, Russian data privacy law is much more like GDPR. And I mean, the answer for this is quite obvious, because Russian data privacy law was adopted because Russia in 2005 joined the Convention 108 of Council of Europe. So because of that, so Russian data privacy regulation have many common things with the European approach. And but in some cases and in some points, so there are quite big difference. And if we compare Russian data privacy legislation with GDPR, so we can see that at some points Russian data privacy law, unfortunately, is quite out of date. So we really should work in our country to improve our data privacy legislation. And back in 2018, our country has signed the protocol 223, and this opened the door for a big evolution of Russian data privacy legislation, because now after the ratification of this protocol, our country will be obliged to harmonize the data privacy legislation to the new concept, to the new trends which we can see in GDPR and in modernized convention, which now is called 108 plus. So we are really looking forward to see the results. But it's about the future. But what is about now? So let me just try to make this deep dive by pretending that we are a legal entity which is incorporated in France, which is selling furniture, and of course which is planning to expand into Russia, like in online or a local office and showrooms. So they would like to have a new website section devoted to brand development in Russia. So they would like to have a local office, and of course they should be bothered by accounting activities. And of course, on other hand, they would like to depend on their global IT infrastructure and of course some HR systems. So in our case, they would like to depend on the global HR through the Workday system. I'm quite sure that many of you are familiar with this application. So first of all, what we should take into account, the legal basis for processing. Let's see what is going on in Russia. So, like in overview, so mainly we have the same legal grounds for data processing as there are in GDPR or in some other countries which have GDPR-alike legislation. And but in practice, there are huge differences. And first of all, Russian Data Protection Authority unfortunately rely on the consent as the main legal ground for data processing. And so it's quite opposite to the European approach, because in the European Union, in GDPR, consent, yes, it's recognized legal ground, but we have to depend this on the last place. So before we can use consent as a legal ground, we should examine if there are other more suitable and more transparent grounds for personal data processing. Unfortunately, in our country, it's opposite. So, but quite common with the European Union and other countries, we have special rules for sensitive and biometric data. And of course, the last thing, that legitimate interest, unfortunately, in our country, it's a very sad story, because many data protection officers and even companies, they had seen a quite skeptical position of Russian Data Protection Authority about legitimate interest. But maybe it's because Russian companies in common, they do not have experience by documenting, by making legitimate interest assessment for just to prove that there is any legitimate interest. And of course, so all you need is consent. So consent could be provided in any form. Most likely, which you could be requested by Russian Data Protection Authority, is a written consent. And of course, we have a special consent for data dissemination. And this is like innovation of the last year, because before that, so you can just have ordinary written consent, but for now, you should have a special one. And of course, written consent. So in which cases we do need written consent: transfer of employees' data, processing sensitive data, processing biometric data, and transfer of data to third countries failing to provide adequate data protection. And it's also quite a bit opposite to the European approach, because having a consent from employee in the labor relationship in Europe, so it's a practice which is not welcomed by data protection authorities and courts. But in Russia, unfortunately, in most cases, we have to take those consent to be able to make this transfer of employees' data. And next thing, so if we would like to process data for marketing purpose, so what should we do in Russia? Well, first of all, of course, prior consent is a really important thing if you would like to make these marketing activities. And it's quite the same approach which you have in the data protection legislation and in the advertising law. So both laws say us that you should take prior consent before you can make these interactions with the data subject. And of course, consent must be related to a specific advertiser or distributor of advertising. Consent must be explicit and expressed, so it can be hidden in long text. And consent must be voluntary, so provision of the service cannot depend on the consent. So it's quite the same which we have in the European Union. I mean, quite the same approach. And of course, I mean, in Russia, so we also use checkboxes, but you cannot show to the user pre-activated checkbox, so they should be empty. And of course, well, this is mostly concerning the consent for data dissemination, but anyway, according to the general position of Russian Data Protection Authority, the silence or inaction of the personal data subject under no circumstances can be considered as a consent. So consent should be provided in the positive action from the data subject. And about the targeting and profiling under the Russian law. Unfortunately, we don't have special provisions which regulate this type of actions and activities, but in the same time, you should follow the general principles of the data protection legislation. So content and the scope of processed data must be matched the declared purposes of processing, so no excessive data processing. And of course, you should process personal data if you would like to make like automatic decision making only under the consent of the data subject. And of course, there are many other things which you have to take in mind and take into account when you are planning to have automatic decision making. And this is one of these provisions where data subject could stop this data processing just by any sign. So you could just message the data controller that you are opposite or to the automatic decision making, and data controller should immediately stop this activity. And of course, what are the recommendations on processing data for marketing? So first of all, obtain prior consents for direct marketing, and of course you should store them and manage those consents. Avoid pre-ticked checkboxes and inclusion of marketing purposes into terms and conditions or privacy policy. Of course, you should fit profiling into processing necessary for purposes declared in consents or performance of the agreement, and combine automatic and human processing of personal data. So it's really strong recommendation. Do not rely only on the automated decision-making systems, because you could fall into problems. Next interesting thing which you should consider if you are international company which would like to make business in Russia, so international transfers, so from Russia abroad. Of course, there are some other topics if you would like to export some data, for instance, from the territory of the European Union to Russia, but I think it's more about the GDPR, but not about the Russian legislation, because in Russia, mostly is regulated the cross-border data transfer from the territory of country abroad. So first of all, so global website hosted in Frankfurt, and Russian office has remote access to sales data to organize delivery from local warehouse. So what we should take into account? So first of all, cross-border data transfer or basic requirements. If you would like to transfer personal data to a foreign state, to foreign state agency, foreign national or legal entity, so the purpose of this cross-border data transfer must be in line with the purpose of initial collection of personal data. So I think it's quite obvious. And in the same time, the recipient state should provide adequate protection of personal data. So how we can identify such state? So this state should be member of the Strasbourg Convention 108, or should be in the white list, which is approved by the regulator, Roskomnadzor. And for now, in this white list, there are 23 countries, like New Zealand, Canada, Australia, and etc. There are much more of them. And of course, so we should put in this list of the adequate countries more than 50 members of the Convention 108. But what will happen if we cannot justify that the importer of data, the state, is not belong to the adequate list of the countries? So if countries could not be recognized as providing adequate data protection, so we should use one of the legal grounds. It could be written consent of the data subject, it could be international treaty, it could be agreement with the data subject. And of course, you should take into account that cross-border data transfer to such kind of countries could be prohibited or restricted in any moment by Russian Data Protection Authority. So, well, I have to say that during the last 16 years of Russian data protection legislation practice, there was no any evidence or no any facts where Russian Data Protection Authority prohibited or restricted such data transfer. But anyway, so there is such possibility. And really special and really interesting thing, it's the data localization in Russia. So what is the rational approach? Because there are many myths and stories about that. So, but let us try to be skeptical and practical. So what is the main requirement? So the main requirement is that in case of collection of personal data, including by means of the information and telecommunication internet network, the data controller is obliged to ensure that the recording, systematization, accumulation, storage, clarification, and extraction of personal data of Russian citizens should be done by using databases located in the territory of the Russian Federation. So that is the data localization requirement. But how we can proceed with this story? So because yes, we understand the general concept, but how we can justify a given data processing activity? So first of all, which I can recommend, is that we should justify what are the categories or types of personal data is being processed, because there are 8 categories of personal data, from which 3 of them falls in the scope of data localization requirements and 5 are not. So we can see them on the web slide. So it's provided data, disseminated data, and observed data, which are falls in the scope of data localization legislation, and obtained data, triggered data, assigned data, derived data, and inferred data, they are out of the scope of data localization requirement. And of course, here you can see some examples of this data, and how we can use this approach in the day-to-day activities. Let's pretend that we are DPO of this French legal entity. So how we can, for instance, understand if like online training activity could fall in the scope of data localization requirements. So we can make some decomposition of the main stages of this data processing activity. And as you can see, some stages are fall in the scope of data localization and some are not. So when you are receiving personal data through online web form, so it's could be qualified as provided data. And when you are tracking or monitoring attendance training, so this also could be qualified as observed data. So these 2 data sources falls in the scope of data localization. But 2 other stages, I mean test result calculation and certificate awards, they are out of the scope of data localization. So we can use databases which are located outside of the country. And this approach could save quite a fortune for the business. And of course, we should understand not about what are the specifics of a given data processing activity, but because Russian data protection laws regarding the data localization, they aim to regulate where the data is stored. So what about the databases? What about the information systems? And if you would like to make like an express test of the given system, so you could use this identification scheme of databases to be localized in Russia. So just go through these 8 questions and just answer yes or no. And you can see that really fast you will have a basic understanding if there are any risks of falling a given system or a given database in the Russian data localization requirement or not. And so I think it's quite useful and practical. And of course, so if we understand that some of the systems falls in the scope of data localization requirements, so we should understand how we can proceed with these risks, with these requirements further. So we can choose one of the 8 strategies, and some of the strategies, they are really in the green zone, so they are really on the safe side, and some of them not, because unfortunately in Russia the data localization law was adopted in 2014 and entered into force in 2015. So it's more like more than 6 years of practice, but still there are many unclearness, and unfortunately Russian Data Protection Authority and even Russian courts, they don't have consistent understanding and harmonized understanding how we should judge in different cases if the system is compliant with data localization legislation or not. But in any case, so you can use one of these 8 strategies, and of course, depending on the legal risk estimation. So if you can see the 0 point, so it means that the strategy has 0 risks. And of course, for instance, if you would like to have a strategy number 2 leave as it is, so it will mean that the amount of risks will be really high. And Just example of strategy number 7, which is most popular in Russia. So if you would like to have an interim database where you will collect personal data from Russian citizens, and because Russian data privacy legislation does not prohibit the data transfer afterwards, so we can use a local database to collect personal data, and then we can make a cross-border data transfer and use this data for other purposes abroad. And as I was saying, so this is, well, quite fine. So hopefully this will also help you to understand what could be exercising, I mean, some of the strategies as a just practical approach. And of course, accountability, quite important thing. So what are privacy accountability considerations? So first of all, Russian Data Protection Authority, it's a federal service for supervision in the sphere of telecom, information technologies, and mass communication. Unfortunately, it's quite opposite to the European approach. So Russian DPA is not fully and truly independent one. So because it's a governmental body. So in some cases, it could create some conflict of interests. But anyway, what we should consider, first of all, that data protection data controller should maintain a list of activities which could be used to notify Russian data protection authorities. So because we still have the system where data controllers should notify Russian DPA. And of course, Russian Data Protection Authority is having this list of notifications where you should identify main information about the data processing activities, and among others, you should also notify Russian DPA about what DPO is appointed. And in Russia, you could appoint as DPO not only a natural person, but also a legal entity. So it's quite a surprise, because in the European Union, you should have a DPO only as a natural person. But in Russia, you could choose. And of course, Data Protection Authority, so manage data subjects complaints. And what data controllers should do, they should not ignore requests from data subjects sides, because otherwise you could fall in a big problem. And of course, DPA conducts data protection inspections. So the main requirements for data controllers are to publish privacy policy on the website, of course, and to develop dozens of internal documents. So unfortunately, in Russia, data protection as an internal activity, unfortunately, it's so-called like paper-based. So we are much more about the formal side of this activity, but not about the essence of the data privacy. And of course, this makes me quite unhappy. But some companies, they are really aimed to gain the proper level of data privacy, because they are receiving many information about the European approach and the European experience. In some Russian companies, they really would like to position them on the market as a companies which has pure and true data privacy practice. And of course, the penalties. So violation of basic data privacy requirements, the fine will be up to 500,000 rubles. So it's not so big. So about like more than 5,000 euros. But if you violate of data localization requirements, so you could pay a fine up to 200,000 euros. And this year and last year, some of the American companies like Google, Twitter, Facebook, and WhatsApp, they were fined for the non-compliance of data localization, and their fines, they were quite big. Of course, we cannot say that it's quite big fines in comparison with the European approach. So we don't have fines like a percentage of turnover, a year turnover. But I think that in next year, or maybe in the coming years, our government will make some changes in this approach. So they will put the European style as a manner how we can make some penalties for the data privacy violations. And of course, well, one of the biggest threats is if you make some violations in the web as a company, your website access could be banned by government. And if you fail to comply with repeated orders by Data Protection Authority, they could suspend your business activity up to 90 days, but those cases are quite rare. And one of the last slides, so the penalties for violation of data protection requirements. So as I was saying before, so you can see some examples. And as I was saying, it's not about only fines. For instance, LinkedIn website is banned in Russia for the 6 years now. So it's quite sad. And this is it. So it's all presentation. Hopefully it was interesting for all of you.
Thank you very much, Alexei. Spasiba. Thank you very much for presenting the situation in Russia. I was wondering, in your opinion, if there will be other fines from the Russian Data Protection Authority, because we know that there are many companies in Russia who are developing AI software, who are very active in the field of cybersecurity. So there are many companies that are active in this field, and I'm wondering if the Russian Data Protection Authority had a look already on their activities, or if they're okay, or what was the situation with the big tech companies in Russia.
Well, big tech companies, especially foreign ones, they are also in the area of risks. And of course, many of those companies, they were been already inspected by Russian Data Protection Authority. But I mean, just if we don't deep dive into some political background, so mostly all of those companies, they are successfully passed this inspection. Of course, there were some propositions and recommendations from Data Protection Authority and some administrative fines, but nothing special. So I think that what is in the scope of interest and attention of Russian Data Protection Authority is really big tech companies which accumulates personal data of dozens of millions of Russian citizens. So I think it's quite the same like in China, because they are really trying to regulate how foreign companies use this personal data, and I think it's quite the same story in Russia.
Okay, thank you very much. And I'm wondering if the public institutions are also under the scope of the enforcement activities of the Russian DPA, if there are any fines stipulated over these public institutions, and if there were any fines, because we know that the GDPR allowed member states to impose or not to impose through the national legislation some fines against public institutions for not respecting the GDPR. I'm curious, how is the situation in Russia?
Well, in Russia, so it's the Data Protection Authority can impose some fines on the public bodies. So there are no legal restrictions to do that. But unfortunately, it's quite a rare case. So in mostly cases, as I was saying before, because our DPA is also a public body, so they are just making really strong recommendations or orders to change or to modify or to ban some data processing activities. For instance, I know one case which was 2 years ago when Russian Data Protection Authority ordered to dismiss Google Analytics from a public body's website. So they were saying that this usage of the service meant that it's cross-border data transfer and you don't have legal basis, and because it's a public interest and etc. and blah blah blah. So please turn off Google Analytics on your publicly available website. So, but mostly, unfortunately, so they are having like not public but internal discussions and some promises and etc. So it's quite untransparent for the society, and I cannot remember any significant fines for the public institutions. So unfortunately, as I was saying. So Russian DPA is a member of public body system, so they are just negotiating and no enforcement from their side.
It is very interesting that the Russian DPA recommended the Russian public authorities not to use any more Google Analytics, because in a very recent scenario, the European Data Protection Supervisor, which is the authority that enforces the regulation for the EU institutions, we know that there is a special regulation for the institutions on how they process the personal data, is based on the GDPR, with many similarities, but it's slightly different. We know that they recommended one of the institutions in Brussels not to use any more Google Analytics. So it seems that Russian DPA did that before, based on their data. We have a question from the audience. If you could tell us which is the biggest fine that you know in Russia that was ever issued against any private entity for breaching privacy legislation.
Well, I must say that the biggest fines are quite specific. So if we're talking about the basics of data privacy, which is, I mean, quite common for all countries, like in the European region or in the former USSR. So those fines are quite small. So the biggest fine was like about 6,000 or 7,000 euro. So it's relatively small one. But if we examine what is the practice regarding the data localization, so the biggest fine was imposed in the end of the last year, and it was imposed on, if I'm not mistaken, it was imposed on Google, or on Facebook. So it was like 15 million Russian rubles. So it's almost 200,000 euros, because they do not comply with data localization requirements. And such a big fine was imposed because previously in 2020, Facebook was already qualified as a lawbreaker regarding data localization.
I see. So basically, they started to discuss with Facebook that look, you are infringing our Russian legislation, and we guess that it didn't end up very well for the US company.
Yep,
Okay.
like the same with LinkedIn back in 2016. So they had received some notifications from Russian data protection authorities. So please be compliant, and this took almost 1 year. And after that, DPA just went to the court and asked court to make a decision that LinkedIn should be banned for good in Russia. And unfortunately, they tried to resettle all the matters, and one of the vice presidents of the LinkedIn, he traveled to Russia, to Moscow, and had a meeting with Roskomnadzor's Russian DPA representatives, but no good results. So LinkedIn is still banned here.
Okay, Alexei, thank you very much for accepting our invitation. Thank you very much for the presentation over the Russian legislation. And we will definitely follow any legislative developments across Russia regards privacy and data protection. And thank you very much for being a speaker for our audience.
Thanks a lot. My pleasure. Have a nice day or evening or morning. It depends.
Thank you very much. We are now. I know that we are a little bit over the schedule, and we are very sorry for that. We are on the last stage for our event. We have two more speakers. So bear with us, please. Take a coffee, take something to eat, and because I can promise you that the discussions will be very interesting. Will continue to be very interesting, hopefully for the audience. We will also launch a question on the YouTube chat. So please have an eye. I will let you know, but please check the chat in around 25 minutes, because we will launch a feedback form for our audience from YouTube, and maybe also for our audience on Facebook. Now, from Russia, we will go to Republic of Moldova, where Diana Buchuskan will talk about the Moldavian perspective and how is the situation with the privacy and data protection in Republic of Moldova. Diana is a data privacy officer and an ethics and compliance officer within Moldcell, which is a telecom company from Republic of Moldova. She is in the privacy compliance field for the past 9 years, and she's leading the data protection compliance. Diana is a member of the European Association of Data Protection Professionals, as well as of the Privacy Research Association. For her, privacy is not just a job, but even a passion. I quote, "It's awesome doing the job that you love each and every day." I end the quote. Diana, thank you very much for accepting our invitation. Bună seara, welcome on board to our international trip. The floor is yours.
Bună seara, Sebastian Dan. Mulțumesc pentru introducere. Okay, I will switch to English. Thank you, Sebastian, for introduction. Hello, everyone. Thank you for having me. It's an honor to be here with you today. Well, I have prepared a presentation, and I will. Okay. Oh, here it is. So I will talk today about Moldovan's approach to data protection. But before that, just let me steal a few minutes and introduce my country, because I suppose perhaps some might ask themselves, where is Moldova? Have I heard correctly? Or Moldova or Maldives? No, it's not Maldives. The Republic of Moldova is a landlocked country in Eastern Europe, bordered by Romania to the west and Ukraine to the north, east, and south. The capital is Chisinau, so we are a non-EU country in the central part of the Europe, between Europe and Asia. Over the last decade, the priority forms of tourism of Republic of Moldova have been rural, wine, cultural tourism, health, and beauty tourism. And here are the top advantages that I could present. So you are more than welcome to visit our country. Okay, and further, I will start with a few facts about the history and the evolution of data privacy in Moldova. Well, Moldova signed the convention in 98, the Convention 108, and ratified it through parliament and decision in 99, and it is in force for our country since 2008. With the adoption of the law on personal data protection in 2007, however repealed in 2012, the authority responsible for the controlling over the compliance of personal data processing in our country became the National Center for Personal Data Protection. Pursuant these laws, the center obtained the status of autonomous public authority. As well, we had until recently a government decision on requirements on assurance of personal data security, data processing within the information system of personal data, namely based on ISO 27000. Also, during 2017 and for period until 2019, we had EU twinning project to harmonize our national legislation in the field of data protection with the European Union's legal framework and European standard. So that in 2018, Center have proposed a package of personal data protection based on GDPR and Data Protection Directive 680. This proposal has been approved in the first reading by Parliament, but until current moment there are lots of debates due to some gaps or differences between the GDPR and our local draft. Recently, I've participated in several working meetings where have been engaged the National Authority for Data Protection, even the director of law Latvian State Data Inspectorate, if I spell it correctly, to share the experience from EU countries, some business association and other experts in this field for producing the best possible version of these laws in order to be more in compliance with the GDPR. Of course, we had controversial debates, but finally agreed to a version that satisfies all opinions. So we are waiting for the second reading approval for the Parliament in order to have a law based on GDPR, because the current one is based on Directive 95. By the way, Republic of Moldova is a member with observer status within the European Data Protection Board starting from 2018. The acceptance of the Republic of Moldova as an observer member in the European Data Protection Board represents a first and a major achievement in the Eastern EU space at the present, because the Republic of Moldova is the only state that hold this status within this European Data Protection Board. So we have a law, personal data protection, it's actually based on Directive 95, and we have a national authority that's supervising this sector. But recently, our country have some amendments to the law, so to ensure the level of personal data protection aligned with the GDPR requirements. It's how to say, like a short-term solving of the main obstacles until the Moldovan GDPR will be adopted. So the main legislative amendments on the personal data protection is about the notion of consent of subject personal data has been amended to the GDPR ones. So it covers the possibility of consenting through a statement or an action. Also, the notion of profiling has been added in our law. Instead, the requirements of notification by data operators at the center on the processing of personal data have been removed, as well as the registration of all the operators in the public register of personal data operators. By the way, this register was recently erased by the center. Also was removed the authorization by the center for cross-border data transfer. Based on these named amendments, cross-border data transfer is based on the principle of free movement of data within the member states of European Economic Area and the states which ensure an adequate level of data protection. But this list is approved by the center anyway. If we are talking about the cross-border data transfer to countries that do not provide an adequate level of data protection, this may take place under some conditions, like consent of data subject between companies in the same group of under some certain conditions, based on standard contract for cross-border data transfer, developed and also approved by the center. So we have these dependencies from our authority. Also have been included the requirements to assess the impact of data processing operations, then to consult the center before processing the data if the processing operation indicates a potential increased risk. Also, the obligation to designate a data protection officer has been included. So step by step, we are closer to GDPR. If we are talking about the main challenges, I remember that the biggest amount of data that we produce every day is truly mind-boggling. And as you know, 90% of this information is personal data. And of course, this come to some data privacy challenges. And here in the presentation are the most challenging issues that, okay, in my opinion, that for example, in our country at the moment we have bad data culture, if I could say. For example, we still have the tendency, probably left after Soviet Union tradition, to collect and to hold onto as much data as technologically possible. And our society do not understand that those days are over. We still believe that more data is always better, but that's not longer automatically true. Today, keeping data is increase the risk of breaching privacy laws, increase the risk of losing this data. So forward thinking need to balance the value of collecting, storing, and processing large volumes of data against the requirements for privacy, security, and of course compliance. So in my opinion, the solution instead is to build a great data culture that understands the value of data and data privacy. Another challenge that I could emphasize is embedding data privacy. Unfortunately, many businesses only have data privacy tagged on their IT security or disaster recovery plan. But of course, that's not good enough, because data privacy touches many parts of businesses. So you can't afford to treat privacy as afterthought. Yes, I need to be. We need to be to have a data strategy, or to have this staff training. So I understand that it's not easy to ensure that you could collaborate with all the departments, but to get buy-in in all departments, it's a must. Of course, another big issue is a long list of regulations and documentations to follow, because it can be difficult to keep track of what level of data privacy you need to achieve when you have a lot of different data sets. But of building processes, data mapping, automating as much as possible, of course, you can make it easier to handle those complexity of different regulations. And we, of course, do not forget that data privacy is more than compliance. Another challenge is, of course, costs. Keeping your system secure and preventing data privacy issues is an enterprise level can be very, very expensive. But of course, the cost of data breach are also significant. So we need to bite the bullet and invest properly with the efficient costs. What else I could say? Of course, the authority lack of resources. The impact of the society, the guidance for operators, and all this link between the data subjects, the operators, the authorities, we are all are suffering because of this lack of resources. And of course, I couldn't touch this point when we are talking about the data protection officers that also face a lot of challenges, because a DPO must implement a privacy program where he or she must put the theory into practice. And this is real challenge, while wondering how do we make all this theory practical. And by the way, I remember the a quote of Albert Einstein. In theory, theory and practice are the same, but in practice they are not. So I think, you know all what is this. On my screen, I put like a kind of DPO role. Yes, the DPO position is a professional role with many responsibilities, but the basic one is to successfully juggling between helping the company comply with data protection laws and keeping customer trust and business strategies, of course. And one of the most demanding challenges, for example, what I face is a lack of proper support from the stakeholders in the organization. Yes, key stakeholders like head of IT, CMO, the board, or business owners, they are crucial in order to success with the privacy program. And the DPO cannot operate without these key figures. Also, another challenges, of course, is a lack of cooperation with other organizational units, because there is a lot of things on your plate when you're a DPO. For example, from monitoring compliance with the data protection laws and cooperation with the supervisory authority to handling complaints, providing advices, and so on. It's unreasonable to expect that one person will do everything. That is why the division of responsibilities and the cooperation with other organization units is crucial. Different organizational units need to cooperate with DPO to identify personal data collection points and data processing activities, and updating all these procedures, educating personnel on data protection policies directly relates to everyday task and is not only the task of DPO but also all the privacy champions from different units. However, it's not uncommon for DPO to encounter resistance when trying to push new policies, new organizational culture to already established parts of the organization. And in this situation, of course, a cooperation or a proper boost from the top management can be a good help. Lack of personnel, another challenge. And of course, in our country, when this new amendments have been entered into force, it's not any secret that the privacy market has gone through a talent crisis. Yes, it has become quite challenging for a DPO to find the right people and assemble the privacy team. The lack of talent is just one possible reason why DPO despair when it comes to assembling this team. Another challenge is lack of budget. Because we know all the companies, they are trying to for cost savings, and they are dictating the number of employees in the privacy team. And the department is, especially when department is not the core business. Another challenge that I have faced is lack of DPO tools, especially in our country. We have a vision of where we want to take with the privacy program and what steps need to be taken to achieve. But of course, we need the technical execution, and it becomes increasingly difficult to administer and to propagate data protection rules across the organization systems, monitor GDPR compliance, keep compliance records of processing activities, and have an overview of all data processing practices. And of course, I could mention also the lack of judicial practice. given that the field of privacy in our country is quite new, but I could say even GDPR came into force only almost 4 years ago. There are not many legal decisions that could help the DPO in interpreting the provision of the law or the GDPR. Also, DPO cannot influence how that practice will evolve. What are the required or what is the interpretation of the GDPR that can be sometimes tricky, since some terms are not elaborated, or some articles can be interpreted in more than one way. So there are a lot of challenges that we are juggling. But anyway, I think privacy, it's a field where we can explore. It's very complex, but it's a must in our day, because in a digital era, privacy must be a priority. I think that's all from me at this moment. Thank you for your attention. I've tried to go through all the presentation as fast as I could, taking into account that we are going out of time. So thank you once again for your attention.
Thank you very much, Diana, and thank you very much for your kind presentation of the recent legislative developments that happened in Moldova. I know that you have an active data protection authority, and I know that one might say that the Moldovan Data Protection Authority is fearless, because it was also active for both private entities and public entities, and they have done some they have done their due diligence and their controls. Are there any fines which are mentioned in the national legislation for public authorities for not respecting the legislation regarding privacy and data protection? And if there are some fines against some private entities that you would like to mention for our audience?
Regarding the public authorities, of course, there are some gaps that our national authority in personal data protection found, especially when we are talking about law authority services. So there are a lot of issues to be discussed. I will not go through all these obstacles that are facing the DPA, but in regard with the private companies, well, we had a big data breach a few years ago, and how I said earlier, due to the lack of awareness in the society, the attitude of the society was very, how to say, they don't have anything to hide. And in this regard, the private company had the very low penalty, and this was a motivation for other companies. Okay, for me, it's better to pay this low penalty than to be in compliance with the law, because it's more cost efficient to not be in compliance, but to go further and to pay just the penalty. So this is the biggest gap in our country. That's why we are lobbying to have the law based on GDPR, in order to have this level of data protection, and to have this free movement of data between on cross-border transfer. This is critical for all private and not only private companies, because due to digitalization, we need this adequate level.
Thank you very much, Diana. I would like to continue the discussion on the Moldavian legislative system on privacy and data protection, but I would not like to leave our next speaker to wait too much. Thank you very much for accepting our invitation, and thank you very much again for your presentation.
Thank you, and have a nice evening or morning for others. Thank you once again.
Thank you very much. And dear audience, before moving to our next guest, please don't forget to fill up the feedback questionnaire that was published by my colleague. And without further delay, and we are sorry for the for being late behind the schedule, but I guess that the discussions were so interesting that this is the situation. It is my pleasure to introduce you Mr. Punit Bhatia, who is a strategic advisor and help CXOs and DPOs to develop and implement privacy strategy. Punit helps you create a culture of privacy. He is the founder and host of the Fit for Privacy podcast and the author of the book like Be Ready for GDPR and AI and Privacy. One of his well-kept secrets is that he is also a philosopher and a coach. If you read his book Becoming a World Game Changer or listen to his Think, Believe, Act YouTube channel, you'll be amazed. Punit has spoken at more than 40 global events, and he is here with us to share insights and perspective on the international dimension of data protection, but also on the data protection situation in Belgium at the EU level. Now I would like to welcome him and ask you to give him a warm welcome. And now I proudly present to you Mr. Punit Bhatia. Thank you very much for being with us tonight, and the floor is yours.
Thank you so much, Sebastian. I hope everyone can hear me, and it's good to be with you. I'm glad that you are here after 4 or maybe 5 hours, still counting, still ready for more content. And I promise you that I will do my best to make it interesting. First and foremost, thanks to the organizer for considering me, for having me in the second edition. I was also here in the first edition, so it's a proud moment to be part of such an elite event, and it's very well organized. So thank you so much for that. Second, to everyone who's listening, I saw just a moment back there were 75 or 76 people online, so really appreciate your patience for 5 hours and still here. Thank you so much. Stay for a few more minutes, and I promise you that your time would be worth. So what are we going to talk about? We're going to talk about privacy in 2022. That is, what is it that executives are talking about or asking? So we are all privacy professionals, and people are asking us some questions. How do you do this? How do you do that? What? And we as privacy professionals have a challenge or the challenging job of answering those questions. So I've curated 5 such questions, which when I talk to people, executives, DPOs, they are asking. And I thought I'll share them with you, not only the questions, but what are the answers that I usually give or the advice that I usually give, so that you can take benefit from it. Before that, I think we already spoke about that I'm from the company Fit for Privacy, which is founded and owned by me. So without much delay, let's get into these questions. So first and foremost, the most common question is, people do a privacy project, maybe 6 months, maybe 3 years, based on the size of the company, and then they say, is that good enough? Well, that's a very fair question. If you spent a few millions or a few hundred thousands, the question is, have we done enough? Are we done? And the usual answer is, I don't know, or it depends. And that's not an answer which executives want to hear. They want tangible answer. And some of us consultants tell them, well, privacy is not a project, it is an ongoing journey. That is also true. But apart from the philosophical answers, the question is, how do you demonstrate that enough has been done and you have taken a risk-based approach and you know the risks and you're going to mitigate those risks? So there are a few options that we usually say you can take. One of them is put in a control framework or a monitoring framework wherein you define some 15 to 20 controls and ask business to demonstrate that those controls are working from design and effectiveness perspective. So what do I mean by that? Let's say there's a control that we must be transparent towards our clients. So now that's a control level. The way of measuring it is that there is a privacy notice and a cookie notice, and those privacy and cookie notices are being made available on each form. Sounds so logical. Go to the next level. You say design perspective. Is there a privacy notice? Is there a cookie notice? Somebody says yes, test of design passed. Next level, effectiveness. Now you can create a bad privacy notice copying from a Google search or even by yourself, or have a very good privacy notice which is fit for purpose. Is that fit for purpose, or is that somebody copied established? So you ask a few more questions on a control about effectiveness, saying, does your privacy purpose explain the processing activities which you carry out? Are these processing activities matched to lawful basis? And questions like that. And when you ask that, you would have a list of risks, you will have a list of questions, you will be able to demonstrate test of design, test of effectiveness. Of course, not everything will be okay because there will be some risks and some gaps. And that's what you want to know, so that when you go to your board, when you go to your executive, as a DPO, as an executive, as a sponsor of privacy, you are able to say, yes, we've done enough. We did a control assessment and this is what we found. These are the risks and we are working on it. And then you can demonstrate that it is not a project, it's an ongoing journey. So we did the project to set things up, but now we, on an annual basis or every 2-year basis, run this control assessment, and maybe once in a while also do an audit of how things are, how good or bad things are. And now audits are expensive, whether it's an internal audit or an external audit, and you can't do it every year. That's why it's my recommendation to create a control framework and implement it. Ask the business to do a self-assessment every year, and every 2 or 3 years or maybe 4 years you do an audit. So that's the first thing, if your project is good enough or not. And then it's a fact-based evidence which you have created. Next thing is, every one of us does trainings, and then when we go for the next training budget, the question is, do our staff know about privacy or enough about privacy? And there's no right or wrong answer, because we did the training, some of us had the test and they passed the test, and we all know how trainings are done or training are followed. None of us likes it. So the question is, do staff know about privacy? Because that's where the biggest risk is. And if that's where the biggest risk is, how do you mitigate that risk? So the way I usually approach this is, I ask, what is your objective? And they say, we want to establish a culture of privacy. And the question is, how do you know there's a culture of privacy? That is, how do you know staff are paying relevance, importance, or attention to the right topics? That is, when a new project is being launched, are they paying attention that privacy team should be consulted? We don't know. And the way to know is, like we do an employee satisfaction survey, conduct a privacy culture survey. So that's what we do with some of our clients, and say, let's do a privacy culture survey, find out how your business or how your colleagues think in different departments. And then from that, you generally know which department is thinking differently on different topics. And where there's a gap, like somebody says the data breach process is, I don't know. Of course, you have a data breach process, but most of people in that department are saying they don't know. So that means it's about educating them on the data breach process. So if you find out those specific examples, specific questions which staff are asking, you can address them rather than going around and creating some standard training. And of course, then you can also go for job specific or department specific trainings. That means your procurement department and your HR department have different privacy needs. And if they have different privacy needs, you cannot give them the standard privacy training. They need to be relevant for their job, relevant for their day-to-day function in the department. And that's what you can manage. So rather than asking the question, do your staff know about privacy, conduct a privacy culture survey, find out where the gaps are, and then run a project, run a few initiatives to close those gaps. Another question that is usually asked is, have we secured our data transfers? Again, it's a security question, but it's also a legal question. Security from technical perspective and the legal from contractual perspective. And we all know the story of standard contractual clauses. We need to do a risk assessment. And if we do a risk assessment and if the data is getting transferred to the US, there's no way we can say it's 100% safe. Now, if it can't be 100% safe, how can you say your data transfers are secure? That's an interesting question. And the way you handle it is, as the EDPB said, perform a transfer risk assessment, a risk assessment before the transfer is executed. Document the findings, list the findings, take mitigation action where possible, perform anonymization on the data, pseudonymization, not anonymization, and give access to rightful data and make it difficult for someone to get hold of the data. So that's how you manage, how you secure. And of course, you need to have the right contractual measures and everything from that perspective. Now, there's another question that usually comes. That is, how do we keep up with the new privacy laws? Because a few years back, about 5 years or 4 years back, it was about the GDPR, then it was about the CCPA. But now we see that for most companies that are having business in multiple countries, it's becoming challenging. Every country is passing a law. Last year, China passed it. This year, probably India would pass it. A lot of US states have passed their law. Canada recently upgraded or refreshed their law. So where are we headed? How do we manage this situation? Do we have to create a new project every time a privacy law is passed, especially in a global company? And how will you make your staff understand about these privacy challenges? Now, these are tough questions, but these are real questions if your company is operating in, let's say, 50 or 60 countries. And the simple way is, take an international approach to privacy, because privacy is no longer a EU question. Privacy is an international question. And if it's an international question, look at the various laws, look where your company is operating majority or where it's having its majority of business. According to that, implement the strictest possible standard, and I call it create an international or a global privacy policy internally based on the strictest laws. Where possible, where needed, create deviation, but the standard is that international approach to privacy rather than an exception every time. So exceptions as exceptions and international approach as a standard. Like, you have a privacy notice. Now, do you create a privacy notice for 75 countries in which you operate? I don't think so, because if you create it 75 times, that means there are going to be 75 varieties. And to manage 75 variances, variables, or varieties, or 75 people, and making sure all of them are communicating the same message on 75 versions, it's going to be a challenge. I can promise you that. And I've faced it many times. How do you handle it? You take an international approach, put together one unified, single, global privacy statement or privacy notice. Make sure it accommodates the business, because if you are in the business of manufacturing, you are in the business of manufacturing and you know why you collect personal data. If you are an insurer, you're providing policies and you know what personal data you're collecting, what you do with it, and why you do it. Same for a bank, same for a telecom company, and so on. So your business usually is more or less the same. So why do you need those 50, 60, 70, or 80 privacy notices? No, you need one. So basically, take an international approach to privacy, implement once, and cater for exceptions as needed. And of course, if you're doing a privacy notice, you may need to provide the list of DPAs in different countries, but that can be a list. But privacy notice can still be the same. Is it simple? No, it's not, but that's the right way to do. So if you need to comply with laws across multiple countries, the best way is implement a privacy policy, global privacy policy across the company. Let your legal manage that policy. When your company operates in a country where new law has come up, or a company is going to a new country, at that moment your legal team with privacy team would update this privacy policy, and the business would take necessary action rather than starting from scratch. So that's another question which is usually being asked. Now, one of the most interesting questions, or at least for me, from my perspective, from how I see it is, and I know I'm running it through, but I want to finish it fast so that your day ends, and if you have questions we can look at that. Another question is, are we ready for an audit by authorities? The simple answer is, let the authorities audit you, but that's an expensive proposition. You want to be ready before. And how do you become ready before? You become ready before by doing the right things. Now, what are those right things? We can talk about all the requirements of the GDPR, but that will not help. And the simple way to do it is, the way we recommend is, put in what we call a privacy register in place. So what do we mean by privacy register? That is, have a list of all the decisions you have made on privacy, why you made it, what was the rationale, who made it, when they made it, and when was it reviewed. Example, you don't have a DPO assigned. Maybe you made a choice. That was the reason. There was maybe a consultant who advised you. Maybe the advice was right or wrong. But if you have evidenced it, if you have logged that decision, and when something goes wrong, you are able to explain it, it's much, much, much easier than saying, yeah, we didn't assign a DPO because the consultant said. Who consultant? Which consultant? When did he say? Who approved it? Those are the questions, and you will be fined. If you are able to demonstrate, either you will not be fined or the fine would be lesser. So you are able to handle those audit questions. Same way, keep a record of processing activities, keep a log of all the individual rights, keep a log of all the risks, and so have a register which keeps all these information at one place. When the authority comes in, the first thing you do is you give this register to them. And when you give this register to them, what happens is, at least for a few hours, they are busy with the register. And they're not asking you any more questions. And those few hours you can mobilize other things. And then most likely the question would be, you say this in the register, by the way, how do you do it? Can you give us the evidence? And also you give them the privacy policy that you have implemented in the company. So they are giving you remarks on the policy rather than the other things. And then you are demonstrating compliance with that policy. So if you handle compliance in that way, you're ready for authorities. But do we have a privacy register with all these things? That's a question we need to check. Do we have a policy which we can give and saying, this is how we implement privacy in this company? That's a question to ask. So the right question is not, are we ready for the audit by authorities? The right question is, do we have a privacy policy, or can we demonstrate which requirements in privacy laws are we complying with? Can we demonstrate when we made what decision, and all other questions? And if you're able to do it, you will most likely be ready for the authorities. And of course, you don't want an audit to happen, but you want to be ready for it. And that's what we recommend. So in short, if I was to synthesize and summarize all the 5 questions, I would say, evidence your choices. That is one big thing I will suggest. There's a question, is our project sufficient or not? Evidence, how have you established it? There's a question, does our staff know about privacy or not? Evidence, how did you establish that your staff knows about it or not? There's a question, do our data transfers mitigate the risk or are secure enough? Evidence the choice. How do we keep up to date with privacy laws? Evidence, how do you do it? Demonstrate, how do you do it? And have a tangible, traceable evidence around it. And are you ready for the audit by authorities? Again, the same thing, evidence your choices. With that, I would say thank you so much for your having me. I know it's late, but if you have questions, I would be more than willing to help you. I would say thank you so much for your trust, and it was wonderful to be with you. Have a very good evening or good day based on wherever you are.
Pony, thank you very much for your very interesting and final presentation for our today's trip. I think that it's very interesting that everyone should ask themselves, why should I care about privacy and why privacy is important. And I think that you answer to some of the questions from a private entity towards more on a company entity. We need to care about privacy. Privacy is important. GDPR is an evolution, not necessarily a revolution, and things will continue to develop, right? Because digital technology is here to stay. We have seen it, and there are many discussions and there are many negotiations going on at Brussels level, which implies, of course, the European Union, but also at international level within the UN and within other international organisms. However, I'm curious about your book. I know that you wrote a very interesting book with our Brussels bubble colleague Eline Chivot, and I'm saying hello to her as well. What do you think that is missing, or the actual proposal for the air regulation should have? Do you think that the EU already missed this train, regulating AI only now that we know that AI companies are selling their softwares? We have examples of AI companies processing all the photos across the web, and other good examples as well as bad examples. In your opinion, what do you think? Is the EU lagging behind with the legislation on AI, or do you think that it's the normal way of doing business across the EU?
Well, my opinion is that it's always very easy to say this is not there, that is not there. But if you look at it from a regulator's perspective, who are also human beings like all of us, they have a very challenging task. First thing is the technology moves so fast and it's not possible to keep track of and preempt this will happen and create a law. The laws will always follow technology. Technology will lead, laws will lag. It's the same with GDPR. I mean, the iPhone came in 2007 and the GDPR came in 2016. The internet came in 1992 or 1980s, and the 95 directive came in 95. So first technology happens and then the laws happen. And by the time the laws are approved, which is a 2 to 3 year cycle, the technology has already changed. And we always say, this is not there, that is not there. And it's easy for us because that feeds us and our businesses. But practically speaking, from a regulatory perspective, it's a challenging task. And I think the AI regulation is the right step. If you look at, not many countries have an AI regulation. We're sitting here in Europe with an AI regulation and a solid AI regulation, which does not impose strict regulation, but it's a framework approach like the GDPR. And it says take ownership, take accountability, demonstrate transparency, and the other principles. So I believe that's the right approach. Why do we need a regulation? Is we need a kind of a frame or a framework. You can't have the road and say drive responsibly. That's not going to happen. So you need to give some guidance, and that's what the AI regulation gives. But the field of technology, field of AI is so challenging, so quickly developing, that it's practically not possible, and we will always say this is missing, that is missing. But if you look at it in the right spirit and right approach and the right mindset, this is sufficient. That's the same thing we said about GDPR a few years ago, and still we say cookies is a nuisance. Well, it's not the GDPR which is a nuisance, it's the cookies which are a nuisance. So don't try to regulate cookies through a law, but fix the problem. And if you see with Apple and the changes that we are having in last 1.5 year now, even Google is saying we'll eliminate third-party cookies. So we are going in the right direction. But why? Because of GDPR. So the technology is shifting a bit, the Titanic is shifting a bit, but the Titanic takes time to shift. So same thing with the AI regulation, because I don't have that specific examples yet because it's a recent regulation.
Thank you very much for your answer, Punit. Now going a little bit back to privacy and back to evidence your choices. What part of the GDPR would you choose to be improved, let's say in the next years, to keep up with the present technological developments? In your opinion, what should be, let's say, improved there and what is not working yet, as the legislators had in mind when they started the discussion around 10 years ago?
I would say there are a few things that need to be fixed. And there's one, the e-privacy regulation, which we keep talking about. We don't know when it will come. I would rather say, if it's needed, e-privacy regulation, again, if it's needed, make those changes within the EU GDPR and let it be one version rather than two, because nowadays for cookies and communications and emails, we still keep referring to the EU privacy directive, and that's a little bit of a challenge. Same thing around the legitimate interest in it. Now, it creates a lot of flexibility for companies to make choices, but a little bit more guidance on that, little bit more specificity on that would help. And also adapt to the current context. Some of the data is flowing in the modern world a little bit more swiftly than before. So we need to remain a little bit more open. If we are looking for an adequacy should be much more broader. But just by saying, here are the standard contractual clauses, perform your transfer risk assessment and mitigate the risk, we all know, in spirit of word and each and every word, and in spirit of every word in the law and the guidance, nobody would be compliant. So let's not get into a state wherein we know nobody is compliant and we are saying do this. So there, I would say a little bit more pragmatism, little bit more flexibility would be appreciated, because we all know all this technology usually flows from the West, that is the US. And if you're putting barriers or putting, say, gray areas into data transfers over there, we are not helping anyone and we are not serving anyone. So those are some of the few things I would say we need to clarify and emphasize a little bit more than it is right now.
Okay, thank you very much. I know that we would love to talk more about these topics, but I also conscious that I'm the only one between the audience, as well as my delightful last speaker Punit, and dinner, and maybe the end of the day that everyone would like to relax, to disconnect. Punit, it was an honor to have you as a speaker here. Thank you very much for your presentation. We wish you all the best in your future endeavor, and we look forward to seeing you at our next events.
Thank you so much. Thanks for having me. And I wish you all the best for your day tomorrow. I know it's in Romanian, so I won't understand much, but all the best. And I'm sure you'll have a great day.
Thank you very much, Punit. Enjoy your evening. For the audience, we will move now towards the conclusions. I would like to thank you all for being with us at this on this international trip across the globe. We have seen different legislative systems in 10 countries. We have seen that some of them copied the GDPR, some of them are inspired by the GDPR, but they still have their own specificities. And we have seen that some of them, they are far away from the GDPR, and they are far away maybe from providing an essential, adequate level of data protection as the one provided by the GDPR here across the EU. I would like to conclude by saying that privacy, it's a fundamental right across the EU, and we should not forget that. And one that should say that we should not care about privacy because I have nothing to hide, it's equivalent to the fact that we have the freedom of expression, but I don't want to go to say anything because I have nothing to be said. So then, to conclude, I think that privacy is important around the globe. I think that many legislative changes are to come in the US, in the federal states, as we have seen, in Australia, in Japan, in April, in Canada as well, there might be some legislative developments. We shall not forget that the European Commission is now assessing all the adequacy decisions which were based on the former directive of the former Privacy and Data Protection Directive. This report might be published even this year or maybe next year, depending on the European Commission agenda. We know that Argentina still has the DECUS decision, and also the legislative developments there will be very interesting to be followed. We have heard about what the legislative developments in Russia look like. We have heard about the legislative developments in Republic of Moldova. Their legislation is almost similar with the GDPR, but there are still some things to be decided and to be improved. Therefore, I will not keep you anymore online. Thank you very much for being with us for these 5 hours across the world. And I would like to remind you that access to the proceedings of this conference is free and does not require registration. But if the participants wish to obtain a certificate of participation, it is necessary to register by the end of this event, either on the event website or to the portal dedicated to IAPP members. All the papers of the conference and presentations are recorded on YouTube, and all the discussions will be available for free of charge to all those interested in reviewing the presentations of the 10 speakers that we had the honor to meet today when traveling virtually around the world. I wish you a very great day, great evening, and great weekend, because the weekend is close by. Thank you very much. Bye-bye.